Maybe it's one of the division bench matter.
Sorry?
Division bench matter. This is maybe. Plus hearing is concluded.
Hey, what do you want?
It's maybe listed in the next sitting when the matter.
The division bench will sit then only, then?
It is assigned to court number
No,
2.
that's why it is not
You
permissible.
have
That's why
to
I'm asking.
mention there.
Court number
The
20.
division bench matters are assigned to a particular bench. You have to mention there.
But in this case, matter is already been hearing is concluded, and matter.
Nothing can be done. You know, the honorable judge is not well to what to do.
That's why. If any day, if any
Judgment
day,
is reserved.
yes, my lord, on for a necessary order, it was.
Have you filed the written note of submissions?
No need of written note of submission in this case. That's why we have not filed.
Let us see.
The Registrar General is the opposite party. They have
We'll
already.
see what.
That judicial election matter.
Item 45. Mila.
35.
45.
45.
First time it has come, Mila. NI Act matter, Mila.
45. What is this matter is about?
NI Act, Mila.
NI Act.
Mila.
NI Act matter can't be adjourned.
Sir, first time I assume they contact करता है.
First time.
Mila. First time I assume.
45.
Comforting.
No, see, 2007, these are matters are pending. 138 matter. Just imagine.
That's true, Mila.
6 months is the time frame granted and under the statute.
That's true.
And we are not able to dispose of 2007. Just imagine.
That's true.
What can be done? Monday.
Next Monday.
This Monday. 18.
May I seek your lordship permission to mention matter coming by way of mentioning memo, my lords?
Yes.
This matter was earlier heard at stage of 482, my lord. Now we are against discharge, rejection of our discharge application. I'm only praying if it can be listed, my lords, on 21st of May, my lords.
See, 21st and 22nd, even if I list, I don't think it can reach because the last 2 days, you know what happens. You can try and we can put it on 20th. We can see 20th or 21st.
21st, which is
you can try your luck on 21st.
I'll take my chance, my lords. I'll take my chance because this matter has, at once initial state was heard by your lordships, my lords. So it will not take much time.
Give a memo. We'll see you. 21st will. I'm not sure whether it could be taken up. I don't know that there will be rush on that day. Anyway, we'll see.
I'll take my chance, my lords. I'll take. I'm so grateful, my lords. Deeply grateful.
Yes.
Item 67.
Yes.
67. Sub item 2.
67.
My lords.
What do you want?
The appellant is dead, my lords. In the year 2022, we have sent letters. And that endorsement comes deceased. Sub item 2.
Okay. What about the first one? 95 appeal. How it is tagged with the 2004 appeal?
I don't know, my lord.
67 if you come. Just check it up. The first, sub item is 95 and 2004. I don't know how it is tagged or it has to be separated. I don't know. Just check it up and tell me. Just see from there. Okay.
Item number 43.
May I be pardoned, your lordship? May I be
Yes.
May I be pardoned, your lordship?
Yes,
Item 61 and 62 of my lord's list. On behalf of Mr.
Yes.
Palit, I was praying my lords may permit me to take a copy of the brief from the registry.
Okay, these are the matters, 95 matters.
My lords.
Matter arising out of acquittal or what? What is
My
this?
lord's brief has been, we are not able to trace the brief in the office. That was why I was praying my lords that I may be permitted.
But in any case, you do one thing. Why don't you come to the court so that you can collect it from
my
here?
lords. My associate is.
When the matter will be called up, you just tell me. Just I'll accommodate, but let us understand. Okay, I'll accommodate. Don't worry. Okay.
I'll be there at the time of it being called, your lordship.
Yes, let him bring the pen drive and take the soft copy. Okay. Get the pen drive when the matter will be called up. Just remind me.
My lord.
Yes, next.
My lord,
Much obliged, your lord.
One more mentioning is there. Some online mentioning. Yes. Mentioning. Okay. Yes.
Modification of order, my lord. Bell.
Item number 43, Your Lordship, on behalf of my senior Kashinath Patnaik, appearing for informant. I will kindly praying for adjournment, Your Lordship.
43.
Yes, Your Lordship.
Okay. 43 2023 matter.
He's appearing for the informant.
That's it.
Informant, Your Lordship.
43. Yes.
Blessed, Your Lordship.
Yes.
Supplementary list, item 1.
Yes.
Let's at the last occasion, Honorable Court directed to serve the copy on the OIC. Let's have served.
Lordship, I am appearing for on behalf of Mr. Vijay Kumar Dastu.
Yes.
Lordship, instruction ta assi nahi after vacation.
Why? Let us see what is the matter. It can be disposed of. We will dispose it of. What is
Yes.
What is it?
The matter is I made an application under 6 clause 1 of the RTA Act. Thereafter, the response wasn't satisfactory. Therefore, I filed a first appeal. Now, in first appeal, no order was passed. Therefore, I filed second appeal. Now, the second appellate court had second appellate authority had directed the opposite party number 2 to take a decision, but the decision has been taken by the opposite party number 3. And the desired information has still not been submitted, my lords. We prayed that the documents must be given. No document has been given, my lords.
See what is the MP in order just so.
Yes, my lords.
Which one?
Page number 52.
52.
52, my lords.
Oh, yeah.
Paragraph number 7. After receipt of the notice on second appeal number 878 of 2022 from the Honorable Commission, the concerned section of OSHB were again requested on 4/11/2025 and reminded on 13/11/25 to return the file with required information. But the administrative officer Urban informed that the file was received by Sri Devendra Patra, the dealing assistant of the concerned scheme in the year 2022, who has already retired from the board services. He has not handed over the charges of the concerned file to his successor. Hence, file is not traced out.
If the file is some information is sought, you can't say that some dealing assistant was handling and he has committed office. He has not given the charge to anyone. Have you taken any action against that Devendra Patra? These are the information you have to give. What kind of plea you have taken? Let him file reply.
Mallards, if the Honorable Court permits, they cannot, because Mallards, opposite party number 2's order is by Odisha State Housing Board. But my learned friend appears for opposite party number 1. Who is
Separate panel.
yes, Mallards.
And who is appearing for 2?
Separate panel.
Orissa State Housing Board. Nobody is representing.
Notice.
Service is affected on 2. Just see.
No, Mallards, notice hasn't been issued on 2.
Notice as notice to opposite party number 2 to file within 2 days. That's all. Yes. In the meantime, let the respondent opposite party file their response if any. We don't to do same. Within 1 week, please the matter. After waiting. Yes, next.
Item 2.
Please, your lordships.
Mallards, 2 and
Mayor,
3.
please, your lordships.
2 and 3. Okay.
Yes,
Your Lord.
great.
Yes.
Mayor, please, your lordships.
Fine.
Your lordship, I am suffering from fever. Kindly adjourn.
What is it? Okay. We request it made on the 3.
Lordship,
Request it made on the petitioner. Please the matter given. Yes, next.
Item 4.
Item 67, my lords. I'm sorry. That item number 1 is appeal against acquittal. Item number 2 is conviction, appeal against conviction. So the second item was the appeal against conviction, the person died. The first item, the appeal against acquittal.
Then let me see. I'll call for a report in all the cases. Let me see. I'll recommend it. Don't worry. I'll call for a report from concerned.
Lordship, item 2 and 3 on file memo and appearance memo and
Yes, to
on behalf of Mr. Vijay.
take the memo and so for PS.
In item
Yes.
2, your lordship issued notice.
Yes. And now 5. 4. 6. 5.
Now
4, your lordship.
4. Yes.
Mallards, in this matter, Mallards, an application was made. Mallards, certain informations were received.
Are you an RTI activist?
No, Mallards, these are the 2 matters only on RTA Act. Both of them are listed today, Mallards.
Yes.
Now from 10 informations which we sought, 1 to 6 we received, 7 to 10 no information was given. Therefore,
Then you file appeal.
yes, my lords, first appeal was filed. Now, my lords, as no decision was taken, second appeal was filed. In the second appellate authority, my lords, transcribed that the petitioner's case is not maintainable, my lords. But my lords,
Where is that one? Item 5, na?
yes, my lords, relevant page 31.
Item 4, na? 4. Yes.
4.
Yes.
Relevant page 31.
31.
Yes.
There is. Oh, you are arguing something else. Is it Sagar Jena?
My lords, 3.
3. 3 is he is saying notice. He has entered appearance in fact response. Yes. 4. Yes.
Item 4.
Item 4, Your Lordship, I am appearing for the opposite parties. Your Lordship, you have received instruction that the petitioner has already received the Aadhaar card number for which he had approached this Honorable Court, Your Lordship.
He's already received.
He has received, his brother has not received because he has not.
My lord, just a minute, Milan, just a minute. My lord, who has received some instruction
Yes,
that
sir.
one of his brother has been issued, another brother could not be issued with non-appeal of mind, non-submission of application, but department is told if intimate us in this regard, we should to file affidavit details, then it will be complied with. After vacation, let's make it.
What affidavit we can dispose it up?
No,
On-
we
on
can
the basis of your
ultimate
statement.
disposal of, but the thing is this instruction what is given, orally it is not surprisable. Suppose tomorrow, if not, DPI is a.
Then why vacation? Why vacation? You next week you tell me I'll dispose it up.
Next week, next week.
No, next week.
Yes, sir.
Tell me when do you want?
Yes, sir.
You get written
Next week,
instruction
any day.
on the way.
Yes, written instruction
Okay,
by we will
okay.
file the affidavit.
And let it be 19th.
Yes.
19th or 20th.
Gratefully.
You get that instruction on the basis
Yes,
of
sir.
this.
Yes.
I'll file an affidavit.
Yes. Yes, next.
Item 5.
Yes, 5.
Millard, in this case, I have not received the case diary.
Let's may reflect my name along with Mr.
Yes.
Kumar also, Milan Kumar also.
Give in right. Yeah.
Because of Millard's, the investigating officer put under suspension, he has not handed out the investigation file, Millard. So, Lordship,
No,
because of
the
the
petitioner is not appearing in the first, before law demand not appeared. And last time also nobody appeared. Right.
what are the file?
Non appeared the petitioner at the time of court. On 13/2/2026, when the matter was listed before Deputy Registrar Judicial Law Demand, non appeared for the petition. And subsequently on 24/4/2026 as well, none of the petitioner. When the matter is called up today, again nobody is view of the same. The ABPL is listed. Yes.
Item 6.
Statement Miller, accusation Miller, illegal transportation of 9 number of Miller cattle and Miller co-acted on the maintain of legal bail and so far the criminal antecedent concern I have.
Yes, have you checked up?
Millard, 6 cases, Millard.
So bail.
Just earlier, Millard, in case
You are habitual.
he has written that one PS case, criminal antecedent. Because of that, he has verified only TBR PS case.
You have disclosed how many? 1, 2,
6.
It's a 6 case, Millard.
Yes.
Similar cases, Millard.
All similar cases.
All similar cases.
You are a professional.
Professional
analysis.
Hmm?
I am not apprehended at this spot. I was remanded in this case on the basis of the.
His name is there.
In the FIR, your name is there.
Yes, name is there.
এই স্পটে ধরা পড়লে করে ডাকুଥିଲେ
Let us see. What is your name? Your name is Taju.
Yes.
Tajuddin Khan. Yes. Read the evidence.
Yes, Mr. कुछ नहीं. We tried to stop the Swift Desire car by standing in front of
I think you remain for at least a month.
ମୋର ରହିଲେଣି ପା ହଜୁର 5-6 ମାସ ହେଲା ଏକ ମାସ
After vacation,
ସବୁ କେସରେ ହଜୁର ବେଲ ଦେଇଛନ୍ତି
Okay, ଆଉ ଗୋଟେ ମାସ
କାଲି ବି ଗୋଟେ ହଜୁର ଦେଇଛନ୍ତି
Not
କାଲି ବି ମତେ
that you are not entitled. You are entitled, but
entitlement there is no materials
ଅଛି ଇଏ ଦି ଜଣ
I am saying you are entitled to bail.
since
I am saying you are
since
entitled
number
to
of
bail,
criminal
but as a deterrent you should
he
remain.
is a habituated criminal millers in this millers
We have seen
connector.
6 cases.
6 cases my lord I admit and all those cases are remand case. गोटे केस रे apprehend कले तापरे
How cases arrested?
arrest my lord से केस मु bail पाइगनी my lord that is my lord बड़म्बा PS केस नंबर 377 of 2025 ସେଥିରେ ହଜୁର ମୁଁ ବେଲ୍ ରେ ପାଇ ସାରିଲି
ଏବେ ଆସୁ ଆପଣ
ଆର ସପ୍ତାହକୁ ଆସୁ ଆଉ
ଆଫ୍ଟର ଭ୍ୟାକେସନ
ନେକ୍ସଟ ୱିକ୍
ଆଉ ରହୁ ମାସେ
ଖରା ଛୁଟିଟା
ଖରା ଛୁଟିଟା ଗଲେ ଭଲ ନା ଖରା କଣ କରିବି
Pinch up of this thing. You will be entitled to bail. You are
ନେକ୍ସଟ ୱିକ୍ ଆସୁ
ଖରାରେ କଣ କରିବୁ
ଲାଷ୍ଟ ପାର୍କିଂ ନେକ୍ସଟ ୱିକ୍ ଲାଷ୍ଟ ପାର୍କିଂ
22nd.
ଲାଷ୍ଟ ପାର୍କିଂ ଡେ ଦିନ
22nd.
ଆଉ ପାଞ୍ଚଟା ପାଇଗଲେଣି କହିଲେ ଆଉ ଗୋଟିଏ ହେଇଗଲେ
I am telling you are entitled, but because of 6 cases you are habitual. So therefore you should feel the pinch of it. You know.
ଆର ସପ୍ତାହରେ ଶେଷ ପାର୍କିଂ ଡେ
22nd.
ଏଇ ଗୋଟିଏ କେସରେ ଗଲେ ମୁଁ ବାହାରି ଯିବି ସେଇ ହଉଛି କଥା
ବାହାରିଗଲେ ପୁଣି ଆଉ ଥରେ
Then again you
ଆଉ କରିବି ଥାନାରେ ଆপিୟର କରିବି ହଜୁର
that,
କଣ୍ଡିସନ
that condition would be there.
Yes,
Actually,
sir.
every
Appear
Sunday, every Sunday,
ଆଜ୍ଞା
every week he has to appear for at least 6 months. I'll grant in case you have to pursuant to the order issued also comprehensive affidavit has been filed disclosing therein that the petitioner is rewarded in similar kind of 6 cases. Because Pondal had counsel for the petitioner submits that the petitioner was taken into custody in which one? Boromanda PH case?
Below
Boromba PH case 77.
2025
The 77 of 2025, and thereafter he has been remanded to all other cases, including the present case is concerned. There is no direct evidence against the petitioner. The petitioner was not even arrested on the spot. The co-accused who was arrested on the spot disclosed to him of the petitioner. On the basis of which the present prisoner has been remanded in this case. Co-accused has been granted bail.
yes ma'am
He further submits that the co-accused was arrested from the spot. He has already been granted bail. In view of custodians,
12/1/2026
the petitioner is custody also. In view of the authority, the citation grant after the office. Mr. Mahanti, counsel for the state, submits that the petitioner is an habitual offender. Since he has 6 similar antecedents, stringent conditions should be imposed in the event to allay the apprehension of the state counsel. It is directed that the petitioner shall appear before the physically appear before the concerned police station. Which police?
Tigiria
Tikiria police station. Tikiria police station on every Sunday from between 10 to 1, 10 to 1 for at least for 6 months. 6 months. And it is also made clear that the petitioner is found involved in any other similar case beyond the 6 cases which has been disclosed. The concession appeal granted by this court shall be withdrawn forthwith on the basis of the application by the prosecutor.
Yes, it's correct.
Your application was 6 cases, all right.
yes
You can't increase your
ନା ଆଉ ବଢେଇ ପାରିବିନି ଆଉ
again କଲେ entitled
ନା
then immediately it will be withdrawn.
ଆଜ୍ଞା ମୁଁ ଆଉ କରିବି
Yes.
Item 7.
My lord, item 7, I'm appearing through VC on behalf of Mr. Gaurav Mohanty, my lords. May I be permitted?
Yes.
Yes. My lord, the co-accused person have already been released on bail. My lord, a murder case. Your lordship can kindly have the order of 3095 for 2026. Omnibus allegations not named in the FIR.
Here is a case millers out of millers 59 charge sheet witnesses. Only 5 witnesses were examined and they are hostile.
All of them hostile.
Doctor and IO has not been examined millers. Complainant and IO doctor has not been examined millers. And in the millers co-accused has been released on bail. That is a finding that there is no eyewitness. But here is eyewitness Antarjami Parida.
Antarjami Parida. So
Last in theory, he has
show me the Antarjami Parida. What is the name of this accused? Ullas Vera. Yes.
Yes.
Antarjami. Just see. Who is Antarjami?
Antarjami Parida. More name Pinkua.
Has he been examined?
Not examined, Milord. Not.
He is the informant.
He is not an informant.
He is one of the witness.
One of the witness, and that he has seen that person is along with that.
Last scene.
Yes, last scene page.
Already.
Relevant. पर्सन मिलर्स उपरोक्त ठिकान आज प्रशंसा एक समय हेब मु खड़ा बाड़ी दांडा आड़ू आसी देखिला बेलू मुड़ी क्लब पाखरे चौरा पाखरे टिकू एवं रमा सोदा सोदी करुला से समय आगरू भी सेमिति झगड़ा हुअंती से मु तांको कथा को एक गुरुत्व देई नथिली से समय मोर एवं बुबुनार कथा हेउथिलु हेले तांकर झगड़ा अधिक उग्र हेबारु मु ओ बुबुना जाई सेमानकु छड़ाइबाकु चेष्टा कली एही समय पापुनी आमको कहला जे तमे एक कथार मुंड पुराओ ना नहीं तुमे एठु पळाओ आमे सेही समय किछि दूर रे वीणापाणी क्लब पाकु गलु सेमान आगरु बहुबार मद पी एमती झगड़ा हुअंती परे घर को जाती सेति बेले टुकुर निज भाई बुढ़ीना ओ संपर्कीय भाई प्रशांत जेना सेटारे आसी पहुंचले ओ तांकर भाई टिकू से झगड़ा करुथिबार देखि रमा को धक्का मारले और धक्का मारी मारी सेटाकू थिबा चौरा पाखकू नहीं गले सेही समय रमा चौरा ऊपर पड़ीगला रमा मीन्स डिसीज मिलर सेतबेलू से पुणी एमाने मारिया ପାଇଁ उठिले सेतबेल प्रशांत रमार पछपटू जोरे जाबुड़ी धरला बुढ़ार रमार डाहाण पट हाथ धरी पापुनी ओ रमार बाम पट गोड़ दुईटू जोरे जाबुड़ी धरला सेतबेलू टिकू रमार सामना पटे छिड़ा होइतला ओ से हठात एक छुरा पकेटू बाहर कला ओ टिकू को हाथ रे धरिया छुरी रे रमार हाथ छाती और देह को घुसी टिकू मिलर हु इज टिकू is the main assailant Millers. But what
is the role assigned to this?
He was present there. Another Millers that witness.
Tiku has been granted bail?
No Millers.
Who Prashant has been granted bail?
No Millers. That is
who got the
bail granted?
My lord, Babuna. Babuna stands with the same.
And Vishwanath.
Vishwanath Swai alias Babuna and another. My lord, that your lordship will find on your lordship's board, which is also there, 3095 for 2026.
There, Millers, there is a there is a finding in the order. There is no eyewitness, Millers. So that's why bail was granted to both of them. In the order itself, it was written, Millers.
What is the what are the
he was present at one
present is something different. See,
nothing,
what is the role of what is the role of this?
No, don't do it.
He was not a main assailant. He was along with the.
What is the role of Papuna? Whether you can draw parity with Papuna?
Papuna's hold the left hand of the accused.
The person who holds the left hand, and thereafter Tikina
is assaulted in the chest and
he has been granted bail.
Papuna has been granted.
Papuna has been granted.
See that Millers, Papuna has been granted bail on the ground that there is no eyewitness. Lordship see that order.
By this court?
Yes, this court.
But all the PWs have turned hostile. 5 of them have been examined and all of them
material witness has not been examined, Millers.
But I stand a better footing than Papuna, your lordship.
The petition submits that the petitioner who has been granted bail? Papuna. And he has been granted 5/4/2026. And it was earlier rejected by this court, huh?
My lord, coordinate bench, your lordship.
Yes. Miller's antemortem injury is antemortem in nature and homicidal.
Now, just tell me what is the difference between the role ascribed to Bapuna, Vishwajit Swai, and the present accused. If Bapuna has been granted bail, whether he is entitled to parity or not, that's the only question.
Correct, your lordship.
And who is the informant?
Informant Millers Nilima Behra,
Nilima.
wife of the deceased.
Oh, whether she has taken the name up for this man?
No,
She's
no.
not a witness. She's not a witness. And
No,
the
Your Lordship.
witness whose evidence you raised.
Yes.
What is his name?
Name is Milord's Antarjami Parida Pinkua alias Antarjami Parida.
You just tell me whether Ullas Bera has a nickname.
No, Your Lordship. My lord, that is what. My lord, whatever is there, records, Your Lordship. The records are there before you.
Wait, Antaryami Parida, you read it, where Ullas name is there.
Ullas name is not there, my lords. Here is a Ullas name is there, my lords. All are bossy ki madhya piyanti boli. One of the witnesses is doing.
Whether he is assaulted.
Because
He is not assaulted. I don't think.
he was present in there.
Present maybe, but he is not participating.
Not assaulted.
Not,
Tell that
the-
not
rather in the contrary, this accused, that is Babuna, has cut hold of the legs or hand or something.
Hand.
Babuna, you read it.
Papuna.
Babuna's role, read it. Read it, Babuna.
ପାପୁନା ରମାର ବାମ ପଟ ଗୋଡ ଦୁଇଟିକୁ ଜୋରରେ ଜାବୁଡି ଧରିଲା।
Then he is directly participated. He has been identified. Right. It is custodians. Custodians.
5-5, Your Lordship.
Custodians,
5-5.
325.
5-5-25.
5-5-25. Right. Petitioner is accused of the case. Out of 20 witnesses.
Now that is 59 CS witness, 5 witness has been examined. Material witness has not been examined.
5 witnesses. Then who all are the material according to Antaryami?
Complainant, doctor, and I also not.
No.
And that
Eyewitness is
Antarjami has not been examined.
Then he has not said anything.
Antarjami has not been.
In this case, the 7 witnesses have already been examined. And none of them have supported the procedures. Mr. Hon'Ble, State Council submits that Antaryami Solidarity is one of the eyewitnesses who has not yet been employed. Besides, apart from that, the informant, the wife of the deceased, has also not been examined. Mr. Mahanti has read out to the statement of Antaryami Kurida. Next, the statement reveals that 3% of Kontu cake or Gurudala reveals that co-accused Bapuna, Vishwanath Swai, alias Babuna.
ପାପୁନା ରମାର ବାମ ପଟ ଗୋଡ ଦୁଇଟିକୁ ଜାବୁଡି ଧରିଲା।
Cut hold of the left leg of the deceased. And who has given the blow? Thereafter, read it.
ମିଲର ସାହେବ ସେଇ ସମୟରେ ଚଉରା ଉପରେ ପଡିଗଲା। ସେତେବେଳେ ପୁଣି ଏମାନେ ମାରିବା ପାଇଁ ଉଠିଲା। ସେତେବେଳେ ପ୍ରଶାନ୍ତ ରମାର ପଛପଟୁ ଜୋରରେ ଜାବୁଡି ଧରିଲା। ବୁଢନ ରମାର ଡାହାଣ ପଟ ଟୁକୁ ତା ହାତ ଧରି ଛୁରା ମାରିଲା।
When he was trying to get up, Prashant, trying to get up, reading that portion, Prashant.
ପ୍ରଶାନ୍ତ ରମାର ପଛପଟୁ ଜୋରରେ ଜାବୁଡି ଧରିଲା। ବୁଢୀନା ରମାର ଡାହାଣ ପଟ ହାତକୁ ଧରିଲା। ପାପୁନି ରମାର ଦୁଇ ପଟ ଗୋଡକୁ ଧରିଲା। ପାପୁନା
And
ପାପୁନି
Bapuna କଣ କଲା?
ଗୋଡ ଦୁଇଟିକୁ ଜୋରରେ ଜାବୁଡି ଧରିଲା।
Bapuna
ଟିକୁ ରମାର ସାମ୍ନା ପଟେ ଛିଡା ହୋଇ ଓ ସେ ହଠାତ୍ ଏକ ଛୁରୀ ପକେଟରୁ ବାହାର କରି ଧରିଥିବା ଛୁରୀରେ
Bapuna, who has actively participated in the commission's crime, as per the statement of eyewitness Antaryami Kurida, has already been admitted to bail by the coordinate bench of this court on 4/5/2026 in bail number 3095 of 2026. By observing agent Parapai,
while my lords granting bail to the Papuna, that statement has not been taken into account.
Para 5. You have not challenged that what to do. Para 5. Para 5. Para 5. We trying up to and other witnesses have not been examined. And the disciplinary note reasons 5 violation and the condition is under the report even absence of failing to appear to report that is for the prosecutor application with the trial court for calling up for the concessions and the trial court need to force the process for
Here is a case, my lords, your lordship specifically adjourned to the after summer vacation.
Which one?
Specific, this case. Specific adjournment was it up after summer vacation, but it was called.
An application is moved. You have moved an application.
Application. I made a mention yesterday before your lordships, my lord, because the co-accused was granted bail, so your lordship allowed my memo.
Where is the application?
No, your lordship has allowed my memo, and that is why it is there on board. I made a mention before your lordships yesterday that the co-accused was released on bail.
They see there is a judicial order. Why are you not? You should have told there is a judicial order that it should be listed before after vacation. There should be an application.
Lord, I'll file an application today. Your lordship is granting bail.
There is an application. There is an application.
Where is the application? For preponement, where is the application?
For preponement, I don't believe, my lord. I believe for interim bill there is there. That is why it has come out.
Interim bill.
My lord, I'm not pressing that application, my lord, today.
That application.
You go to trial court. This is not done. See, I'll tell you why you have to go to the trial court to repeat your bail application. Your bail application is rejected on 12/2/2026. You challenge that order, you came here. On 22/4/2026, I have adjourned it beyond vacation. And thereafter on 4/5/2026, the co-accused got the bail. This is a change circumstances, you go to trial court. How can you mention it and get it like this?
My lord is granting bail, your lordship.
Yes, sir.
My lord, may I kindly have it next week, my lord. May I pray that the matter will be taken next week.
Petitioner has said the order dated 12/2/2026 passed by the additional dispensation judge Kujongo, rejecting the regular bail plea. The matter was taken up on 22/4/2026 by this court, and it was adjourned to be listed after the initial summary vacation. In the meantime, the co-accused had approached this court for grant of co-accused Biswanath Swai, alias Babuna, had approached this court seeking regular bail by filing BLAPL number 3095/2026, which has been allowed by the coordinate bench of this court by order dated 4/5/2026. Relying upon the said order up to the coordinate bench, and counsel for the listener submits that he is entitled to parity. As the role ascribed to the co-accused Babuna is not higher than the voted to the petitioner. Rather, the petitioner, nothing is against the petitioner, but petitioner. Therefore, the petitioner is entitled to be released on bail on the ground of those parity. Regarding to the aforementioned submission, since the since the change of substantial change of circumstances, petitioner to the proofs of the trial court by renewing his bail plea on the ground of parity. Liberty granted to the petitioner to renew the bail plea of the trial court. Would be open for the petitioner to urge all the grounds, including the ground of parity. If such application is approved, it is expected that the trial court shall deal with all the grounds and decide the same express. With these observations, petition is disposed of. Yes, next.
And take into account parity, your lordship, my lord.
Parity I have changed.
Great.
8.
May I please, your lordship?
Yes.
The petitioner is a young girl of 20 years, lordship. Inside custody, my lord, last 7 months, 1410.
What are the offences?
Offense are 21B, lordship.
161
161 grams brown sugar.
And
And charge has been framed. Since though charge has been framed, 21.
not received 161 gram below commercial.
They-
Lordship.
No, but antecedents?
No antecedent.
Where have you said that?
Subject to verification.
Subject to verification, lordship.
Custody since
Custody since 1410 2025.
14?
1410 2025.
10, 2000?
25.
25. 14, 2025. What is the recovery you said?
161 grams. 161 grams.
100 grams plus. And the counsel specifically submits that the petitioner has no criminal intention. Petitioner is a 20-year-old girl, huh?
Girl, lordship.
20-year-old girl, and he's in custody. She's in custody since 14 January 2021. We are doing a period of custody, and the quantity of contraband recovered, granted this. Okay, subject to verification. Yes.
Item 9.
My lord, the allegation against the petitioner is that on 28th March 2023, co-accused Loknath Pradhan had been to the house of the deceased and asked to return his money. For that reason, my lord.
No, you had taken the adjournment to place on record the evidences of the witnesses. Yes.
Pardon your lordship. Tomorrow I will file the deposition of the witnesses, my lord. In the meantime, witnesses were examined, my lord.
My order dated 22/4/2026. Petitioner was granted petitioner was directed to place the evidence up to the vital witnesses. Those have already been in complied with the order, and since 1 week time, leaves the matter. Yes, next.
Grateful, my lord.
Item 10, my lord, praying for
Yes.
after vacation. After vacation.
After vacation. After vacation. Yes.
Item 11.
May I please question? Yes, my lord, the petitioner in custody since 26/7/2025.
Is there is there?
Yes, there is there.
Yes. Publishi?
26/7/2025, my lord.
Yes.
My lord, 27 kilo, first offender, no criminal antecedent.
Yes, madam. First offender.
First offender, my lord.
Yes, madam. What is that?
It was checking the last revision was 5. Submission charge sheet.
After submission of charge sheet, I am fine.
Charge sheet filed on?
Charge sheet filed on, my lordship, that on dated
31/3.
21/1/26.
31 March.
31 March.
21/1/26.
Say, what do you say? Right. Petitioner is accused of no allegation of then the counsel for the petitioner submits that the petition is of time offender and 27 kilos.
27 kilos.
Recovered. Directly recovered from you?
My lordship.
Recovered from you, from him, and after investigation, charge sheet has already been filed on 31/3/2026. Actually, since 26/7/2025. However, we are appealing for by 4 months. 4 months. Every second sentence. Yes. Subject to verification. Yes, next.
12.
And item number 12. I just now got this CD.
Conversation 20B TC of NDPC. It is
97 kg. 97 kg ଅଛି CD ଏଇନା ପାଏ
16/4/25.
Now she got it. 97 kilo.
97 kg
ବର୍ଷେ custody.
ବର୍ଷେ ଦେଖ।
Nothing has been seized. Nothing has been seized.
ମୁଁ ସିଜର ରିପୋର୍ଟ ଟା ଦଉଛି
As per the prosecution case, the informant received some reliable information that 4 to 5 bags were lying in a field and the person was standing near the field. That is the allegation. ସେଟା ଗୋଟେ ପଡିଆରେ ଥିଲା ସେ ପଡିଆ ପାଖରୁ ଏମାନେ ଠିଆ ହେଇଥିଲେ ବୋଲି allegation.
There is no conscious position.
This is the Mylord, kindly have a glass.
He has to read.
This is the kindly have a, I have already typed.
Order dated.
This is the kindly have a glass, yeah, sit.
Pursuant to the order dated 23/4/2026, the State Council has received the CD test now. Next week?
Yes.
Sometime to prepare with it. Please, by next week. Yes, the 13 next week, yes.
The 13.
Yes.
In obedience to the directive this court, I have filed the required affidavit.
Have you filed the affidavit?
My lord,
Affidavit you have filed.
on 11th May. Out of those cases, one case has been disposed of, and another and others are pending.
Where is the affidavit? Have you filed the affidavit? Have you filed the affidavit the pursuant to the order?
Yes.
Pursuant to 23/4/2026, there was a direction to file a comprehensive affidavit. Have you filed? Now, where is that?
Only I have given the tabular chart of the cases pending and disposed of.
Where is that?
Flag D here.
Flag?
D.
Flag D.
What is this affidavit? Let's see the affidavit. What is this?
I'm not
No proceeding pending in the High Court or would be initiated. Caveat nil. What is this? I don't understand.
No.
Statement of fact. As per the environment in MEPL application. What is this? This is the affidavit.
No, my 11th May's affidavit.
Just see, sir, the affidavit. This is the affidavit you have filed. What kind of affidavit is this?
No, my copies there, copies with me.
Lordship is looking at
I
flag
have
D.
given a tabular chart.
Flag D.
Flag D.
Page 70. A table is given.
Yes, ma'am.
How many cases? 1, 2,
8 cases, one has been disposed of, and another relates to another accused. 6 cases, other offences.
What are the allegations? You are appealing for whom?
Sir, on the last occasion, they submitted that the injured is in a state of coma.
You have a CD with you.
Sir, I am
See the injury.
filing the photographs.
The grievous injuries are there, first of all. And second of all, it is the second attempt on the very victim itself. Lordship, may I read the
Same person.
same person, Your Lordship. That was the whole problem.
For last 6 months, I have been in judicial custody.
That
No,
may
no,
be, but you have attempted twice over. And there is another case also.
And
No, yes.
in this case also,
No,
the grievous injury is there.
No, what about the
Other
first attempt? This is second attempt.
The
Second case.
attempt.
In the first attempt, there was another case.
There is
Yes.
a second which is find place in the antecedent, Your Lordship.
Then,
No, my lord, I am submitting one. I may be given 5 minutes time to submit.
yes. Okay.
The accused, the UTP has been in judicial custody with effect from 8/12/2025.
8/12.
2025.
Yes.
The FIR story reveals that the whatever has been narrated by the narrative is given by the prosecutrix is hearsay. No eyewitness was there. Admitted.
Tell me whether same injured person you have earlier attacked or not.
My-
Or that another case is there.
No, that is not.
That
May I read?
No,
May I
they
read?
cannot give the case number. I can move the case number.
Case number ଅଛି.
Hmm.
Case number ଅଛି 285/2025. He has not given
Then there is not the submission, my lord. On the last
Can you
occasion,
see flag D? Flag D, the last column.
they submitted that the accused in
The last series
Yeah.
number, which is calling on our PS case number 285/2025. That is in respect of the present.
Earlier attack.
Yes.
Earlier.
That was a, after the acrimonious exchange, there was a call. My lord, the photograph from Daily.
Decline. Whether I reject or after vacation.
My lord?
After vacation. After vacation.
My lord?
After vacation. Yes, next.
My lord, sir, give me five.
Then
At least I'm submitting, my lord,
I'll have to reject, sir.
My lord?
You have attacked the same person twice over.
No, my lord.
Earlier, no.
No, my lord, see, admittedly,
No will not make, no. There is a case pending.
Admittedly, there is animosity between the two parties. my lord.
But you can't attack one person
No,
twice over.
let me submit, my lord.
Now this time this is grievous hurt also.
Your lordship must give me a present hearing, man. I request your lordship.
I think I am giving you.
No, I'm submitting, elaborating the facts.
And the very fact that if you are a bail
there was no hospitalization.
such a long time, you are not entitled.
There was no hospitalization. He was never treated as an injured person. And on the very day he was discharged,
Therefore, I am not rejecting. Therefore, I am not rejecting. I am listing it after vacation. Yes, next.
And then after 7 days,
Next.
This case has been committed, my lord. Committed to the court of session, my lord. There is no, the accusation never reveals the case of 109 BNS. But the accusation is the sole breadwinner, vice earner. His family members are dying out of starvation. For the last 6 months, he has been in judicial custody.
If your family members are dying, why are you involved in 8 cases?
My lord, I undertake, sir. I will never commit.
You have a very good profession of doing crime.
My
And your family are serving.
No, there is political rivalry, my lord. In the village, there is political rivalry. He belongs to different.
Therefore, not rejecting at this stage. Let it come after vacation.
So, my lord, next
You will
week.
get the bail after vacation.
My lord,
After vacation, you will get the bail. Yes.
after vacation.
14. May please.
My lord, my earnest request, sir, please, for 7 days. Otherwise, the condition, the family will be very precarious, my lord.
Otherwise, also will be precarious. You will come out and do another crime. Better you reform.
They are submitting wrong things, my lord. The photograph, kindly see the photographs. Kindly see the photographs. He is here and letting in the peak of his health, submitting that he is in coma.
Medical report.
Yes.
Medical report.
Medical report and this injured statement भी फोन करी तुमचे.
He is the victim of assault. Sangram Kesari report.
I don't know. Where is the injury? He is standing somewhere you are taking.
Next 1/C is 39, man.
These photographs, he is standing somewhere in the motorcycle you are taking.
No, the last occasion they submitted.
When these photographs you are taking?
photograph.
After injury or before injury?
Photograph. No, after injury.
How will I know?
No, sir, my submitting manner.
it's okay.
Kindly see Annexure 1/C.
The head injuries, let's see.
No.
These are the head injuries.
No, kindly see the nature of injuries.
Doctor will also tell lie.
My lord?
The doctor says it's grievous injury in the head.
No, not head, forehead. And by means of a steel pipe. A steel pipe cannot be equated with iron pipe.
Okay, you give it, I'll write it.
Lordship,
I'll pass you.
Lordship,
I'll pass you.
pass the injury report.
You give the file, I'll pass.
My lord, can
Yes.
you
Next, I'll pass the order. Yes, next.
No, my lord, kindly.
I'll pass the order, sir. Why are you wasting time?
No, I am suffering. I have suffered.
You may suffer, but I have to go by law. I have to go the injury report.
Next week.
No, not next week. Either today or after vacation. Decide.
Oh yes, after vacation.
After vacation. Yes, next. 14.
After vacation.
Lordship has called for CD.
4925. Got the CD?
Your Lordship has called for CD. CD has not come. And this person is from Madhya Pradesh. I would say.
Have you filed the affidavit, sir?
Your Lordship, final prosecution report has been filed in the meantime.
No, you are from Madhya Pradesh. You will file that comprehensive affidavit, disclosing your permanent address and all.
No,
Who will be your local surety?
Only one criminal antecedent.
That's right, but who will be your local surety? Your permanent address. They will verify it. Otherwise, once bail is granted, then you will be evaporating. It's very difficult for them to catch you. File an affidavit.
Next week, let's.
Okay. File an affidavit.
Item 15.
Next week, let's.
Comprehensive affidavit, disclosing the permanent address, local surety, and antecedent as well. Yes. And you will. Yes.
Next week, let's.
Next.
Item 15.
Yes. Pass over. Yes.
Item 16.
Yes.
Offense under section 3032. Last again, Lordship directed me to file a comprehensive affidavit
Filing it. The affidavit there. This is a remand case, my lord.
Why? I don't understand. Why you people are filing it affidavit here? Instead of
Only
filing-
yesterday the person concerned could came to swear the affidavit. The lordship may kindly.
Yes. What do you say?
Now, this is a remand case, my lord. While the petition was in custody in Hon'Ble PS case number 106 of 2026, he has been remanded in this case. And in the original case, he has been granted bail by this honorable court.
Yes. What is
I give in the
There are three
allegation?
CA, there are three CA.
in all the
In one of
cases,
the
he has
cases, he has been arrested and other cases have been taken into remand.
What are the allegations in this case?
मतलब उसका चोरी करी नहीं गए.
everything has been recovered.
Petitioner engagement to engagement of the petitioner. Custody since
Custody since custody since 21 to 2026.
Pursuant to the order dated 27/4/2026, the petitioner has filed a comprehensive affidavit disclosing that he is involved in three cases. The responsible for the petitioner submits that he was initially arrested in Hon'Ble case number 106 of 2026, and thereafter in the present case and other two cases he has been taken in remand. Okay.
Other one case.
Taken in remand. Other cases he was taken in remand. Regarding it to the proceedings which taken on the remand. And he appeal for the concerned police station. Concerned police station. In last second Sunday, for 6 months.
Okay.
Next. Item 17.
Oh, if I may please your lordship, my lord, I'm appearing through
Yes.
this. My lord, on the last occasion directed me to file the affidavit. I'm filing it, my lord. My lord, 42 kilos, 800 grams. And my lord, in custody since 13/10/2025, your lordship.
Where is the affidavit?
Lordship. Yes.
Yes.
My lord.
You have one case each, huh?
Petition number 1 only has one, my lord, and that is an old one, not similar, your lordship.
Sorry?
Petitioner number 1 has only one antecedent. My lord, the details are not available, but my lord, not similar. 2 and 3, my lord, they don't have.
They are from, you have to verify, madam.
Uttar Pradesh and 42 kg 800 grams.
You have to
Not
verify.
3%.
Affidavit.
Not 3%.
The person to the order dated 13/5/2026, the comprehensive affidavit has been filed, which is taken to court. Advance copy of the same has been, the copy of the same has been supplied to State Council, who shall verify the same and
My lord, can I pray it for before vacations, please?
let us see.
I will take my chance. Please have it before vacations. On 22nd also, if your lordships can kindly have it.
There may not be first in the first half of the vacation. These are not only first half of the vacation. Yes.
Item 18.
My lord, may I just pray that can it be moved during the break bench? Your lordship may grant me that
Like
liberty.
I have said that in the first half of the vacation, it will be listed. Yes.
Gratefully.
Item 18, my lord, allegation is that a Sikh, old Sikh, was selling Kripan in front of the Gurudwara. However, हाँ मतलब कहते I am filing it and I have given the address of the local CDP with his phone number.
Verify. Same thing. Verify.
Allegation is that he was
29/4/2026, a comprehensive affidavit taken filed at Chhattisgarh, Raipur. Verified. Verify. The copy of the same has been supplied to the State Council. We shall verify it again. This is the matter in the first half of the vacation. Yes.
Your lordship will check on
Second half.
the detail days.
Last week, you know what happened. Who knows whether you
chance lord. Or Buddha loco.
Everybody will take chance, but there is no chance.
No antecedent.
There is no chance at all. You will take chance, but there is no chance. You know, last week what happens from Raipur, Chhattisgarh, they have to verify. They will take adjournment. What is the first half of the vacation? I am saying that is better. Or second half you want? I look it.
No, first half.
First half. Yes. Item 19.
May I please, your lordship? Lordship, 1 week time may be granted to file the comprehensive affidavit, your lordship.
Pursuant to the order dated 29/4/2022, comprehensive affidavit has not been filed. The council person receives the 1 week time. Yes, thank you. Item 20. Yes.
Application below, the acting persons are helping the locality to opening the bank. And for which they give a file for the
The cyber crime, जो mule account रहे, how
Huh?
50 per year.
Lordship kindly see.
This is
My lord, one important something.
कार नार किछ न थाए
My lord,
account number
कार नार किछ न थाए घरे बसी सब काम करम
my lord,
किछ न थाए
one submission, my lords. The informant has been examined. The lordship have a glance, my lords. He has
It is
not.
not an individual case, sir. The
He has
problem is it is a racket.
No,
If you examine individual case, you are entitled to bail. No problem.
But
No, that is
the
not
deposition.
Gain has to be seen.
No, that is
Amma
not.
account to Amma account this transaction ही है.
That
that
is
is
not
not
the evidence.
Actually, account transaction, कारण ସେମାନେ ଅଲଗା account ବନଉଛନ୍ତି,
mule
alpha
account
ଦେଇକି then
great
that is how.
Full account owner
Or a
also.
movement
That is against Ram Anuj. Ram Anuj is the accused,
Yes.
but he is not a petitioner here, lordship.
CD is there.
CD is there.
Lordship kindly have glad the deposition. After deposition, your lordship think it proper.
charge sheet तो हजूर ही करे charge sheet
Deposition में देखो
How
किसी ही नहीं. There is not a whisper of there is not a whisper of a word against my petitioner Muhammad Irsad, and against the other petitioner of client of my petitioners that other petitioner was
Your petition name is Irsad.
Muhammad Irsad, my lords.
I am for the, my lord, third case, Lawless Varsity, that is all not named in the FIR, my lord.
What are the antecedents?
Antecedent, my lords, I don't have any antecedent, my lords.
Have you filed the affidavit?
Yes,
My lord, I also, my lord, file.
You file all the affidavit, I'll see.
my lords, किसी
Next
नहीं
week,
है.
next
That's
week, all the bring the affidavit on record. We'll see next week. Yes.
और भी affidavit is having the
Bring it on record. Bring it on. Yes.
next week
Next week. Next week. Yes.
Next week, my lord.
Yes.
charge sheet भी एक
21.
किसी ने
Next week. Bring it.
Next week.
Yes.
Last occasion, your lordship.
Diary. Got the case diary?
Lordship, last occasion called for the CD minor.
Yes.
21B antipacid, 130 gram brown sugar.
130 gram brown sugar.
Charge have been friend minor.
My lord,
And petitioner have no antecedent minor.
Where have you said that no anything?
That is affidavit minor by his father.
Yes, madam. No, yes.
130 gram brown sugar.
Huh.
Subject to verification of the antecedent, but we didn't have
My
no
lord.
case died.
Is that you not got?
No, I were called, but we have not received the case died.
Charge have been friend minor.
And let the case diary come because there is a direction.
Last
Case
occasion,
diary-
your lordship directed.
Yes, therefore case diary is not. On 29/4/2026, the state council was directed to obtain case diary. We will get answer of it and see. Next week, huh? Next
Chutti Purvu
week.
Rasmal.
Next week, huh?
Chutti Purvu Rasmal.
Next week, that's what.
But date may be fixed.
Yes.
Okay.
20V2C of NDPS Act, 21 kg charge sheet has already been filed, have no criminal
The
actions.
petitioner belongs to New Delhi.
On the last occasion, a lordship has called for this.
That belongs to the New Delhi.
Where is the affidavit?
I have mentioned in my paragraph, page number 4.
Affidavit disclosing your permanent address and who will be the local security.
Para 6
Because you are from.
No antecedent, my lord, 21 kg charge sheet has already.
I'm asking something else. I understood no.
During investigation, I
No antecedent in Orissa, but somewhere else maybe.
During investigation, the concern I have already taken the said investigation and their local investigation wale seta asitele
Disclosing the permanent address, local security and phone number and loss and that's these things accounts. First half of the vacation. First half of the file affidavit. File affidavit disclosing your permanent address, local security and all. Yes, next.
23 after
During vacation, first half of the vacation. Yes.
May I please, your lordship?
Yes.
Last action lordship directed file to comprehend the affidavit. Today I am filing the petition number 2, 3 and 4. Now I receive the petition number 1 has one antecedent. Just now I received.
File it. Comprehensive affidavit of all.
2, 3 and 4 already filed.
For the sub item.
Well, the
2, 3 and 4 already filed, my lord.
Other installmentally you can't do it. Whatever the sub item, have you filed?
Yes, sir.
Affidavit? Fine. The persons to the order dated 30/4/2023. What is the recovery?
Recovery from the Bugulu Majima.
How much?
Already, amount already recovered, my lord. 3 lakh already received.
300. Or 310.
Yes, my lord.
What if
Already 3 lakh already recovery, my lord.
recovered?
Yes, my lord.
Do you have the case diary?
Yes, no, case there is not available. That's still already filed, my lord.
Charge sheet file. Gold biscuits, 5 lakhs, everything.
Yes, my lord. 160,
2 lakh something is seized and
3 lakhs.
earlier, my lord,
Leave the matter. Next.
bail application is filed.
Bail affidavit and bring the charge sheet also.
Yes.
1522/26 earlier he has filed the bail application. That was disposed upon
Let him file the
25/26.
charge sheet, comprehensive affidavit. Yes, next. 24.
May I please? The
Yes.
last order, she passed May 2026, my lord.
My subitem also selected. My lord, my subitem also selected.
Yes.
And that day I have filed affidavit, my lord, disclosing the amount. And Lordship directed to State Council to take instruction. In the meanwhile, charge sheet has,
Sir.
in the meanwhile, charge sheet has already been submitted, my lord.
No, I think you are not the same. Copy of affidavit is supplied. The council was said to verify the same and from the investigating officer and submit a report. Where is that? It is there or not?
My report is not missing.
See, this order was passed on
Yes,
the
my lord.
1st of May.
1/26. Yes, my lord.
1st of May. 1st May 2026 order has not been complied by the state.
One CA is available, that is the Telco EPS case.
2 days time. Please the matter after vacation. Immediately before vacation.
Before,
What,
last.
you are in custody since?
My lord, I'm in custody since, my lord, 18th February 2026.
18 February 26.
My lord.
What are the allegations?
Allegations.
That's the 84 lakhs.
Allegation. My lord, the 84 lakhs.
84 lakhs, they are
the
money.
my lord, the investigation 36 has come. Then subsequently FIR has been lodged.
The 84 lakhs
Lord,
are in
Lord,
Mr. From the money
Lordship, may kindly say, my lord.
from the company.
I have asked him to verify. Let him verify. Why to waste time? Yes. next.
Before vacation, my lord.
25. Yes. Either you got it?
Yes, my lord.
Yes, sir.
The sure of stolen property allegation and the case is like this, my lord. The police during investigation found no suspicion and fraudulent monetary transactions on the account of Saroj Bag. Saroj Bag, Saroj Bag was arrested. After Saroj, on the basis of the statement of Saroj Bag, petitioner has been arrested. It is alleged that the petitioner.
Saroj Bag got the bail.
No. Saroj Bag, we custody. So what happened, my lord, the petitioner is concerned, they said that the account has been being maintained by the present petitioner. That is the Saroj Bag statement. And said that, I got this bank statement, my lord, also will see. And in course of investigation, they seized another account. Account number that is not related to this account, which they allegedly run by the present year. Lord, mainly the seizure list also, my learned friend has the copy. Seizure list. I would understand. I have also filed a copy of the statement. Only 2 months the account was operated. The account which was being allegedly operated by the present petitioner, only 2 months it was operated. And 1.5 lakh operation has been stopped. But also can you see the account statement from 1/1/24 to 23/3/2026. First year also 8/9 to 24, last is 10/9/24.
The account.
Sorry,
the name of
last
the
is
back. The present petitioner has operating that account and ATM also. That is seizure list also the siege the ATM and the account has seized from this.
সেটা কোন অ্যাকাউন্টে সিজ করেছেন এই অ্যাকাউন্ট আর সেই অ্যাকাউন্ট ভিতরে দেখুন তো আলগা আলগা অ্যাকাউন্ট আমি দেখছি সিজার লিস্টটা
Then Saroj Bag is the principal accused.
No, Saroj, he is the principal accused because in the name of the Saroj Bag, the account and ATM card are used by the present petitioner. That is the statement, my lord.
Yes. What are the materials?
The seizure list. The account which has been seized is not connected to the in the FIR they have given another account number.
How many cases are there against?
No.
File affidavit.
No. Petitioner mentioned coach.
para 6 mention କରୁଛି।
One CG against him.
That to the master transaction ରେ ତାଙ୍କର ଯେତେ ହେଇଛି ଯଦି ହେଇଛି ଆମେ ସବୁଠୁ ମିଟିଂ ରେ seized account doesn't belong to the neither I don't know about the petitioner. The allegation is that petitioner is operating the fair property account.
Petitioner has been operating the account of one Suraj Bag
Yes.
by using all the his documents, ATM card and passbook.
But that account has not been seized. The seizure account is seized.
What is seized now?
The seizure
Account, this
like ଆମେ ବ୍ୟାଙ୍କ ଷ୍ଟେଟମେଣ୍ଟ ଆମେ ଆଣିଛୁ ସେମାନେ ଆଉ ଗୋଟେ ସିଜ୍ ଆକାଉଣ୍ଟ କରିଛନ୍ତି ସେଟା ସିଜର ଲିଷ୍ଟ ଦେଇଛି କପିଟା ଏଇখানে ଦେଲି ଲକ୍ଷ୍ମୀ ଲିଷ୍ଟ ଥାର୍ଡ ଲାଇନ ଆକାଉଣ୍ଟ ନମ୍ବର ଆଇଡିବିଆଇ ପାସବୁକ୍ ନମ୍ବର
IDBI bank.
IDBI passbook number last is 83. Our case is as per the FIR last is 078.
Which bank?
So it's IDBI bank. IDBI bank.
Then same thing you see.
The account is totally different. Account is different.
No.
ये देखो teaser list देखो तो
13701200000685 843.
If I filed page 14 में kindly seen. Page 14 of the bail petition. That's all. Page 14 में 1370 that last হচ্ছে 878. 878. এটা হচ্ছে 838. Allegation is
During the verification, the scrutiny suspicion of financial transaction of the bank, Shankara PS so account number 13701.
account দেখুন তো টোটালি ডিফারেন্ট চার্জশিট भी আছে চার্জশিটের সে অ্যাকাউন্ট বটে আছে এটা সিজার পুলিশ স্টেশন
This is the only Caesar list.
Yes.
Yes, I have a one serial list.
চার্জশিট দেখুন
Yes.
দেখুন তারপর অ্যাকাউন্ট এই যে অ্যাকাউন্ট আমি that account statement I have filed copy only for 2 months operation.
They are putting the number of the account. And they in the name of
Same. Different. You have not seen that real account which is, was being operated allegedly. See, what is the account reflecting in the FIR?
Yes, my lord.
You say that this account has been manipulated and used by this
By the
offender.
yes, my lord.
And you are seizing something else. Where will you take the investigation? Petition is taken into it is Mr. Mishra, senior counsel appearing for the business, has drawn my attention to the seizure list, which is form part of the CD. He submits that the sole allegation in the FIR is that the present petitioner has been misused the account of one Suraj Bag bearing account number FIR page 400 bearing account number IFS 447. It is also alleged that the present accused have taken the bank passbook, ATM card, and SIM card of Sheikh Suraj Bag on rent basis and played through it and earned illegal money. Suraj Bag has already been arrested in custody. The seizure list produced by Mr. Mishra, which is form part of the charge sheet, part of charge sheet has been filed.
Yes, that's right.
Form part of the charge sheet reveals that the investigating agency has seized IDBI bank passport number so and so, which is completely different than the LAC account, which has been used, misused by the petition. Petition is in custody since
3rd March. 3rd March. It's 326.
And the charge sheet has already been
That's it.
filed on.
File it.
The para 6 of the petition you have said, where you have said that no criminal evidence.
Para 6.
in para
Para 6,
Drawing-
page 7, para 6.
drawing my attention to para 6 of the petition. Mr. Mishra says that the petitioner has no inform there submits that the entire case of the prosecution hinges upon the documentary evidence alone, which has already been recovered from the bank as well as from the petitioner, and charge sheet has already been laid down. Hence, no further custody is required in the case. In view of the information. Yes. Next.
26. May I please? Here, my lord, I am in custody since 8/10/2025, my lord. 102 grams of brown sugar.
Yes. Antecedent?
One antecedent is there, my lord.
Not of similar nature, my lord. That is at page.
One antecedent is there.
One antecedent.
One antecedent is there, but not of similar nature.
What is that antecedent?
Yes, ma'am.
Custody since
8/10/2025.
8/10/25. Yes.
Yes.
Have you filed the affidavit?
Yes, no. I have not filed, but in the
File affidavit.
government has
Affidavit to be filed disclosing antecedent and local or outside?
next week, I pray.
Yes. Next.
27. May I please? In this case, my case there will confirm last occasion, my lord.
Yes.
And that is a cyber fraud. That is 36. I pray some more time because the investigation
Next
going.
week, 20th. Yes.
Not if any antecedent have obtained, I will. file
Antecedents also you bring. Next.
28. 22nd.
Hon'Ble.
May I please, Miller?
Yes.
I'm appearing virtually. Last time Your Honor was pleased to call for the records from the trial court. My humble submission is that, Miller,
1 minute, Mr. Mahanti.
Bag E there, my lord.
Yes,
This is
I'm
posted
just-
22/5/25 for argument. Bag E. That probably in this month that matter can be.
Yes, Mr. Mahanti, what do you say?
Miller, my humble submission is that, Miller, there is systematic subversion of all the mandatory provisions of NDPS, Miller, starting from 43 to 50, 52A, 52 clause 3, 55, 57, all these mandatory provisions have been breached, Miller. Moreover, the case commenced without the CE report being on record, Miller. The CE report is yet to be exhibited. The CE report dated 6/10/2023.
Yes, that's right. But you have a very good case for acquittal.
Yes,
Miller, but I
then
cannot.
aim at that. You will be acquitted.
Miller,
why I am telling you is, see, the report has come from the concerned
Miller,
court. It says that the 313 statement has already been recorded.
Yes.
And matter is fixed for 25, 22/5/26.
I'm aware.
For final argument.
I'm aware. My humble submission is that, Miller, I had already wound up my arguments in the month of December. I had also submitted written arguments. The written arguments as well as oral arguments from the side of the PP was also over. So I have been undergoing infinite incarceration. My humble submission is that
I will direct the trial court to conclude the argument on 22nd.
Miller, but I have a humble submission. Both the charges as well as these statements on section 313 CRPC were recorded without any reference to the CA report, which is the basis of the case. That is non-EST in the eye of law.
That is the reason you will be acquitted. I'm sure.
I'm aware. I'm aware. Why should I undergo another 15 days of incarceration? My mother, my family.
I will make sure that on 22nd it is concluded. I will
No,
record that.
That I have also been assured, Miller. But meanwhile, it will take not at least 15 days to be enlarged forever. My humble submission that meanwhile they may kindly be allowed to bail, because last time they were allowed bail, they didn't misuse it. They were allowed bail for 4 months. They have been undergoing incarceration for more than 2 years and 7 months, Miller. Tango Baba Mango Kaharo Devi, the entire family is on the verge of starvation. They are rustic local people. No chance of fleeing bail.
To grant you bail, I will have to venture into the entire evidence which has been brought on record. That
Yes,
exercise,
it will-
that exercise is going to be undertaken by the trial court.
Millard,
Shortly next week.
Millard,
22nd is only 1 week.
I agree. I cannot differ, but my humble submission is that
I'll make sure that on 22nd it is concluded. I'll record that. I'll direct the trial court to conclude the argument.
because my humble, what I humbly beseech your lordship is further incarceration will not serve any purpose. Millard. It will not serve any purpose. So
By order dated 5/5/2026, this court has directed the Sessions Judge cum Special Judge Malkangiri to file a status report regarding the progress of the trial. Pursuant to the same, the Sessions Judge cum Special Judge Malkangiri has placed on record a report dated 12/5/2026, which reads as follows. Mr. Mahanti, learned counsel appearing for the petitioner, submits that he has already concluded his argument in the December 2025, and the matter is being adjourned time to time for argument. He apprehends that even the matter is fixed for final disposal on 22/5/2020. The matter is not likely to be concluded on that day. Therefore, he is insisting for grant of bail. He further submits that the very basis of the case is second in view of non-production of the chemical examination report. Examination report. I have taken note of the aforementioned submission. And regarding it to the report submitted by the court below, at this stage, since the matter is fixed for final disposal just after a week, I'm not inclined to entertain this bail application at this stage. However, I expect that the trial court shall do well to see that the trial is concluded on the date or the fix by the trial court. With this observation, the petition is disposed of.
Millard, a parting reference, Millard. I draw your honor's kind attention to section 52A also. That is also infringed, Millard.
I see at this stage I can't tell all these things because it will prejudice. I have recorded recorded that the EC report is not there on record. I think that's enough indication. Yes. Next.
29. Dispose of Millard.
Dispose. Yes. Next.
29.
Case under section 109, that is 307.
Yes.
Injuries are simple in nature.
7 CA. The 7 criminal antecedent is there.
My lord, 7 CA, but the number 7 item is not mine, my lord.
I don't know who's.
My lord,
Where is the affidavit?
My lord.
Have you filed the affidavit? How many cases according to you? 7.
6, including this case, 7.
7. What is your report?
Yes, just now.
7 only?
Just now I am receiving the affidavit, but in the CD that is the 7.
My lord, I was in custody since 2025, but the police.
What kind of cases are? Yes, this is all 120B. 302 is also there.
Yes, 120B.
25, 27.
I
302 and all.
That case, my lord, is not.
What are the injuries for me?
Simple in nature, on hand, my lord, and 10 months in custody.
And in that all these cases you are on.
My lord, I am on bail. And cases are year old, my lord. Till 2018 cases are there.
You started your career from 2010.
2009.
9.
Yes.
That
is the report says.
That is the antecedent report and this is the new report.
Yeah. Pursuant to the order dated also, company has been filed. Taking on the following. And the affidavit shows that this is involved in 6 more cases.
This is the injury report.
Simple in nature. The injury is simple.
Lacerated wound.
On hand.
ତା ପେଟକୁ ମାରିଲା ବେଳେ ସେ ହାତ ଦେଖେଇଛି
ହାତ ଦେଖେଇଛି.
You were trying to stab in the.
Yes, that is the allegation.
What have you used?
My lord,
Knife.
knife.
ଛୁରୀ
Sixth line of the affair.
Custody since?
Custody since, my lord, 5/7/2025. Almost 10.
Charge sheet has been filed here.
Yes, charge sheet filed on 31st/10/2025.
31st?
10/2025.
10/25. ठीक है. And appear in before police.
My lord, my.
Every Sunday.
My lord.
For 6 months. But custody since 5/7/2025. After investigation, charge sheet has already been filed on 21/10/2025. On 5/5/2026, CD was called for. CD revealed that the injury sustained by Himanshu Shekhar Das. He's the informant?
Yes, no, his brother is the informant.
Brother of the informant there. Are simple in nature, and all the injuries are in the left hand.
Like yes.
Left hand. Regarding the period of custody and nature of injury sustained by the injured, period and the fact that the charge sheet was already filed for it. Until date, to lay the counsel for the state vehemently oppose the prayer of bail on the ground that it's involved in 6 cases. 6 cases starting from 2009 onwards. Regarding to the antecedent of the petitioner, some appearing for the IAC shown to every Sunday. There was 10-1 for 6 case.
Please.
I'll just come. Okay,
modification of letters. Modification were only para 5. This shall be considered by the courts below. Only one prayer, your lordship. If the petition prayer transmits of the record, it can be considered. Without
everything will be controlled by this court. Transmission of record, this happened.
High Court order নহলে মানে
And
গোটে
you tell
কিছু
me
করিব
which pen he will sign, that also I'll write.
নাই your lordship.
What is this?
Without
This is obviously procedural thing. The logistic of the trial court will also be controlled by High Court. The file has to go, file has to be produced before. It is obvious this will have
same but without only
said that it has to be decided means all logistic has to be arranged by them.
If I will see only
It's very much interference, interference by High Court to that extent is not fair.
Some places the trial matter
there. But I have also showed that
maybe practical problem. High Court should deal with all these things. Record should be sent out. All these things. No.
Let's see. I have shown him for. Yes, let's see. Only one.
Very
Very good.
By way of the present application, petition is seeking notification of para 5 of the order cases also. He apprehends that where is the trial court, where is the sessions court?
Only the same shall be considered by the courts.
Same place.
No, that is Banki and Sessions Court Cuttack.
That is the trial court is Banki and the district court is that files pertaining to what is transmitted to the sessions court. In the event in the application is very different.
Let's say time may be extra. Time is
till 30th.
No, I'm pardon. I don't know.
Just come 5 minutes.
And the petitioner has expired. That's
Which
what
one?
I don't know what 53.
15.
53.
53. That was what the petition submitted, that petition has expired. Can you give the date when he
Petitioner has expired.
What is this? 53, na?
In that
Revision.
document or affidavit required. Death certificate or death document.
Record statement and stands evident. Yes. Start.
Item 31. Pass.
Password will be taken out.
So 15 inch.
I don't know 5 mile.
5 plus 15 inch.
Yes, yes.
Lordship, item 31. May kindly pass over, Your Lordship. My senior is on BC, Your Lordship, unable to join the meeting.
Okay, pass over. Yes, next.
32.
Hmm. 32. Pass over. Pass over.
33.
We have another, my lord, praying for adjournment.
Why adjournment? This
The instruction not there.
What instruction? What is this matter?
In night.
You are accused.
Petitioner.
You are challenging.
After vacation will.
When we see because the very initiation of the property hearings. Property cases. I'm just passing it over. 138 matter. It's pending since 2023. Then pass over.
34.
Yes.
Yes, Lordship, I am appearing on behalf of Mr. Devasis Tripathi. This application was filed challenging order dated 7 August 2023 of JNMC Jaspur Road in 1cc 53 of 19, rejecting our petition under section 143A for grant of interim compensation. As per the order in Annexure 4, page number 27, it has been rejected because it is clear from the face of the record.
You are the complainant.
Yes, Your Lordship.
Yes.
It is clear from the face of the record itself, as admitted by the complainant in his complaint petition, that the disputed check was issued by the accused in his favor after allotment of share orally from the joint family property, without proper documentation of distribution of property within the joint family, as it is difficult to determine whether the complainant was indeed allotted the share of joint.
What is the stage of the trial?
I have no instruction right now about the stage of the trial.
If the trial is going to be over, what will you do? See, 2019 matter. You are challenging interim compensation.
We had actually filed this.
By that time, the complaint might have been over. You might have been convicted or something might have happened.
If the Lordship will grant us a short adjournment, I will just seek the instruction at what stage the trial is.
Come on Monday, tell me.
Yes,
If the complaint case might have been disposed of by now, what will you do with this 143 now? Monday. Then counsel, see, this petitioner is agreed by the order dated 7/8. Petitioner will be complainant in ICC 1cc case number 53 of 2019 is agreed by the order dated 7/8/2023, whereby his application under section 143 capital A of NI Act has been rejected for interim compensation has been rejected. It is on the record it reveals that the complaint case is complaint case has been filed on. When was the complaint case filed?
Complaint was filed in 23.
Filed
in
on
2019.
13th February 2019. The counsel for the petitioner has no instruction regarding the status of the trial for the accused, right? Trial for the complaint case. Let him know Tuesday. Tuesday you tell me. Otherwise I'll dispose it up. Yes.
35.
Very well.
Your Lordship. This is a case not under section 138 NI Act, wherein I was arrested and accused in the court of the London JMFCR, Cuttack. My Lord, the contention of the case is someone was issued, but it has never reached me for which NBW was issued. On inquiry, when I came to know NBW has been issued, I was assigned in Kolkata. I filed an application to recall it, which was rejected, for which I am before the Lordship.
You won't appear. You won't appear.
Yes, Lordship.
Won't appear. Where is that? You moved application for 205 application.
But 205 was rejected.
Have you appeared?
First time the advance petition I appeared, which was rejected, Lordship.
No, your 205 application has been rejected.
205 is rejected.
You have to appear. Why 205?
NBW has been issued. Lordship.
Where is that NBW? Show me. I'll say that NBW. Where is NBW?
Annexure 1.
Yes. Show me. Where is that order? There is no NBW.
Rejection of 205.
There is no NBW, sir.
Is to
Yes.
reduce the petition and the case record NBW has been issued against the accused, which is pending.
Where is that?
Page 9, Lordship.
9. Unless they appear, there is nothing. Where are you reading, sir? NBW.
Annexure 1, page 9, Your Lordship.
That's right. Which paragraph? Which? You read it.
The learned counsel with the complainant vehemently opposed the same, perused the petition and case
You have
record.
filed something else, it seems. Learned counsel, learned advocate for both the sides. To me. It's not there. You are reading somewhere else. Amandeep Behra, na? Pradeep, which matter yours? 36. 35 years. 35, na? Pradeep. You have filed something else and showing something else. Just see from record. There is nothing of that sort. This is an order dated 9/8/23, 16/9/2023. And this order is something else. Just see from the record. Come see, show it from the record. Show it from the record. Annexure 1. You are showing something else. Petition, perusal of the petition and the case record. Part of it is not there at all. You have filed something else. Annexure 1 kado bhai, Annexure 1 kado. Just see Annexure 1 here.
54.
Just see Annexure 1 there. Yes, just see. This is something else. Let's see. Read it.
35.
Read it.
Learned advocate for both the sides are present and filed the respective hajiras.
Last line, read it. Learned advocate for complainant vehemently oppose the same. Perusal of the petition and thereafter what is written here? 205. And you are showing
And
something.
case record.
See the record here. What is there in front of me?
Learned counsel perused the petition and 205 said petition.
Then you are showing something else.
Put upon. Here something different also.
I don't know. This is your petition.
Put upon
You have
7/9/2023 to 2027/9/2023.
I don't know. The order dated 16/9/23, which is filed as an Annexure 1 to the petition. Perusal of the one to the petition. The copy of the safe order, which is annexed, is different from the copy, the original order, the original order. Original. The photocopy of the certificate copy is handed over to the court. which is taken on record, taken on record, taken on record. It appears from the impugn order that the application, the petitioner being the accused, receives the summons and after appearance in the court, moved an application under 205 to CRPC, which has been turned down by the trial court, and the NBW has been issued against him. He is agreed by both by rejection of the order, rejection of his application under 205 CRPC, as well as the issuance of those NBW. The counsel for petitioner submits that he is ready and willing to participate in the proceeding, proceeding initiated by the opposite party against him in ICC 1CC case number 195 of 2020. Taking the statement regarding it to the statement made by the counsel for petitioner, the NBW issued against the petitioner stands set aside, subject to the condition that the petitioner shall appear before the court of JMFC bracket R Katak in 1CC case number so on or before 30th of this month, this one, and 30th of this. It is open for the petitioner to reiterate it is open for the petitioner to move a fresh application under 205 CRPC. Such application same shall be considered by the court below on its own level. Either copy please on this petition is disposed of. Yes. Next.
36.
Same Korea, same order 36 will do. Order yes, next.
37.
36. Yes.
37. The company has not been made a party. Similar matter, your the lordship has delivered a judgment.
Show me the complaint is, where does it say?
Or
where it should be checked?
The complaint for 8 items. A copy of the complaint is annexure 2. Page 9. And this is your lordship's order in.
Services also the offense person of the services.
I'm appearing for Mr.
Yes.
Smooth Ranjan Rao. I'm going for a time to reply.
What time these matters are unnecessary pending from years?
Final hearing plus application any date.
And the same thing, have you seen it? Ma Santoshi, you have not implemented Ma Santoshi, and the check was issued on by the Dhirendra Nath Pati, proprietor of Ma Shakti Security. It's proprietorship form. It's a proprietorship form.
Company.
No, company had issued the check.
It's the proprietorship form.
The petitioner, your lordship.
Ma Santoshi, that is infrastructure private limited.
Yes.
Private limited. What do you say? Anita Hada.
Same parties. This.
Monday you take this order and tell your senior that they are covered by this order. Wrong, right, whatever.
I'm handing you over a copy.
Give it. Monday. Tuesday. Yeah?
After vacation, sir.
No, after vacation. Same. Unnecessary, these matters are pending. You don't make it casual.
Wednesday go sir.
Wednesday, okay. Wednesday. As per your request, Wednesday. And only you have to tell that show this order. Same party, whether you are covered or not. Any you can distinguish, no problem. You read it yourself. You can read it.
There also they have considered.
Consider and let him read it. The young man. Yes.
Let that order be kept on record.
Yes. Yes. Next 38.
Addressing left where of notice. Notice addressing left is written side. It will be. One 38, no? 38. Green party without the first cognizance. 22 cognizance order, there is no stay. Then a piece for the petitioner. For now, it is not interested to prosecute. And I can read though, the petitioner has challenged the order dated 22/5/2022. In 1CC case number 2339 of 2022, whereby the court, whereby the letter JMH Orissa is the province of the offense under section under section 138 against the petitioner. The petitioner is pending since 2023. There is no state for the child protection in view of the lapse of time, in view of the statutory command under section 142(2) that the proceeding initiated under section 150 8 of needs to be system of 6 months. 6 months. The 6 months. The matter cannot be pending for certain long time. Many cases petition is not very. The case that is not interested. Dismiss. Yes. 39.
Lordship, on behalf of H. N. Mahapatra, kindly adjourn this matter.
No adjournment, madam. Just the NIA, na? Have you deposited 20%?
Lordship, my knowledge signal is not there.
Sorry? No. This court has directed that the trial proceeding will be stayed subject to you deposit 20%. Have you deposited or not?
Lordship, I have no knowledge.
Requisites, interim requisites have not filed.
Interim order was continued.
The interim order is going on and on. And the adjournment. The while order dated 7/5/2024. The proceeding, further proceeding in 1CC case number 62 of 2018, pending before the JMFC Hon'Ble has been stayed, subject to condition that the petitioner shall deposit 20% of the check amount. 20% of the check amount. Thereafter, the matter was listed on 31/7/2024, 9/8/2024, 17/9/2024, 27/9/2024, and 14/11/2024. 2024. The interim order has been extended time to time. When the matter is taken up today, counsel for the petitioner seeks adjournment. Since the matter has already suffered about 6 adjournment, I am not inclined to further adjourn the matter. However, in the interest of justice, last opportunity granted to the petitioner, to address the to appear and address the court on merits. In the event the petitioner failed to appear on the case, the interim order pass on such and such date stands release the matter on 20th. Interim order I will vacate. I have indicated. Yes, next. What the
Notice not subject. Does address increased.
What is the challenge? 143. Complaint is pending. 2022. This is the petitioner is agreed by the order dated. Where is the order? Order date 29/9/2023, passed by CGM Valikwana in 1CC case number 61 of 2022. 2022 and 16/1/2022.
Item 40, my lord. I am for the opposite party.
Is 41? 41. Huh? It's item 40. 41.
I am for the opposite party.
Yes. What do you say?
I
You are
pray
for the
the matter
complaint.
can be referred to mediation.
You are for the complainant.
Yes, I am for the complaint.
What is happening in the trial? The complaint is pending since 2022.
Yes.
What is happening there?
Today I could not obtain instruction, my lord. If your lordship adjourn the matter on Monday, then I will take instruction.
Good on Monday. Completely for the opposite party and submits that he would seek instruction regarding the status of the trial in 1CC case number 61. Please matter on Monday. You tell me Monday.
My lord.
41. I'll dispose it up and send it to the trial court. Then the trial court let there be a mediation. Why unnecessary pending this matter? Huh?
If your lordship dispose of today, then
But nobody is there.
I will okay. On Monday.
Because see, these are the order of 2022.
Yes.
143 order. And let the trial court take a call. You negotiate there. Yes. 41.
My lord, 41, my lord, I prefer after vacation.
No, after
Because
vacation.
my lord, the petition
This is regarding what? Let us understand.
138 is
It's 138 proceeding, my lord.
NI Act, my lord.
138 NI Act proceeding is filed since 2019, your lordship. And the present petition was filed earlier challenging rejection of 205 of CRPC petition, which has not been described in this petition. Thereafter, another 205 petition has been filed before the trial court, and that has been also rejected. And now under challenge in this.
No, you have to appear.
My lord, in the earlier order, this honorable
yes.
court directed to.
These are unnecessary tactic to avoid the.
My lord, now he is bedridden due to
by the order dated.
neurological problem. I have unread the
Order
document, my
dated.
lord.
See, I have stayed the NBW. You go and appear and renew the application. Petition is agreed by the order dated 22/8/2023, passed by Lieutenant JMFC Nursing Food in 1CC case number 48 of
If your lordship
29.
allow me,
While rejecting his application. under
if your
section-
lordship allow me, on impugn order, 2 order has been passed. They are challenging only 1 order.
One
Madam.
order whereby NBW is issued.
Yes, sir. No, 205 has been rejected.
And NBW.
NBW has been issued since long,
Right,
since
yes.
long back.
Whereby the application moved
Long, 15
under section 205
Teach.
TRPC has been turned down. And subsequent thereto, it appears that NBW report has been issued against the PDP by the order dated 6/2024. While issuing notice to the opposite party, this court had stayed the execution of NBW. Issued on 15/12/2022. When the matter is taken up, the conference of the petitioner again seeks urgent. Since the matter pertaining to an complaint filed on 22/10/2019 in the 20 under section 138 and when the statute provides the stipulated time frame for dispute of the cases under section 138, I am not inclined to entertain this petition. However, however it is kept open to the petitioner to, however it is directed that the petitioner shall appear before the court below and participate in the trial proceeding. And it is so he may move, reiterate his prayer under section 205 CRPC. If such application is moved, the trial court is free to deal with the same on its own merit. With this observation, petition is disposed of. Next.
But fact is, my lord, this is not bedridden, my lord. Neurological,
So therefore, I have given you option. You move fresh application and file all the documents. Allowed. If it is so.
He is not able to speak and
All these things you tell the trial court by moving a fresh application.
Person is only 37 years old.
42. 42. Yes, next. 42, nobody is there. Nice.
Address is not found. Notice.
143 is aligned.
What is he challenging?
Order under 143 of NI.
Enhance the interim compensation. More 20%. Check amount and direct the opposite parties to pay the same. Opposite party must be the
He filed a counter. Like
this is the order they are challenging. What is the status? See, 143 A application was moved and the court has partly allowed saying 1%, you pay 1%. He is seeking enhancement of that. And the it is pending since 2021, the complaint case. And the petitioner is the complainant in one CC case number so and so so and so. Is agreed by the order dated 16/9/2023, whereby his application under section 143 capital A is partly allowed, and the opposite party has been directed to pay 1%, 45,000. That is 1% of the total check amount of rupees 45 lakhs. 45 lakhs. The petitioner is seeking enhancement of the interim compensation to 20%. 20%. The complaint case is pending since 2000. Pending since 2021 date is since 7/12/2021. 7/12/2021. The status of the complaint case is not status of the complaint case is not the letter counsel to obtain instruction regarding the status of the trial of the complaint case, release the matter on Wednesday. Yes, it's made clear that no further adjournments will be granted and any cost in this matter.
44
44, I'm appearing on behalf of Mr. J.K. Khuntia, Your Lordship. We'll remove the defect within a week. We do not have the file with us right now. We'll remove it within.
Notice to opposite party, service is complete, no.
No, defect not removed. Defect not removed.
You have not removed the defect.
Yes, Your Lordship. We'll remove it.
See, this matter is pending since 2023.
Yes, Your Lordship.
And the order was passed on 13/2/2024.
Yes.
Which defect? What is the defect? This is 40?
44.
What is the defect?
State and other mention. Wakalatnama, the opposite party is state, not a party. 22.
The defects pointed out by the staff reporter has not been cured by the petitioner. And last opportunity is the petitioner to cure the defects within 2 days. If the defects are not cured within 2 days, the
Lordship,
CRLMC shall stand dismissed without further reference to the court. Further reference. If the defect is cured, in the meantime, let the matter be listed on 20th.
Lordship, by Tuesday we'll cure it, Your Lordship.
20th. Agar if you cure the defect, otherwise it will be dismissed automatically. Yes, next. It will never.
46.
And yes.
46.
46.
What is the
Yes. 46. Call for the record and hearing both the parties. Other side.
Item 46, my lord.
Hmm.
On behalf of Mr. Devashish Samal, he is emailing, please adjourn.
Sir, this matter is pending since 2007. And the matter was taken up on 9/5/2026. Order was passed, nobody appeared. And it went to the Lok Adalat. There also nothing has happened.
He is ill, my lord, on behalf of
Monday.
Wednesday.
Okay, Wednesday. This criminal revision is pending since 2007. When the matter was called up repeatedly, none appeared. And even in the Lok Adalat, held on 9/5/2026, none appeared for the parties. Let us consider for the petitioners. The adjournment in the interest of justice, reject to 20th. 20th, I'll dismiss you. Yes.
47. I am appearing on behalf of Mr. S.P. Pandya. I am appearing on behalf of Mr. S.P. Pandya, Your Lordship.
For
the petitioner, Your Lordship.
Yes, tell me.
My lord, as per our instruction, the matter has been settled, so we request some time to file an affidavit.
Matter has been settled.
My lord.
Let a counsel for the petition submits that the matter has already been settled between the parties. He wants to place on record the document in that regard. Release the matter on Tuesday.
48.
48, huh?
Well.
48. 2009. लेकिन अच्छा ओके everything there is a brief in the family or learned counsel for the petitioner petition hence this is the matter. Yes.
49.
This
Yes, sir.
No, in fact, I could not get any instruction from the client. nor from the local lawyer. There is some chance of settlement.
2009.
20
Local nobody appeared.
local third occasion rate list is third 20th
What is the check amount?
80,000 only.
80,000.
And the compensation of 1 lakh rupees.
You are for the complainant.
Complainant.
You are for accused.
Contact whether
this is pertaining to which area? Which district court?
say Raurkela.
Raurkela. Shall I send it to district mediation center?
Yeah.
District court mediation center.
That can be better.
What do you say?
That will be more practical.
So that at least they will settle it.
They can appear because no instruction from the client from the date of filing of the revision. Not the local advocate could be contacted. I was trying my best.
Then again, service and all these things will go on.
Yes. So therefore, the lordship may refer to the local.
Mr. Chinchani, learned counsel appearing for the petitioner submits that he has neither had instruction from his client nor the instructing counsel. The criminal revision is pending since 2009. Learned counsel for the respondent, complainant, submits that it could be referred to district mediation center for amicable settlement. Mr. Chinchani agrees to the said proposition. In view of the conjoint submission by both the counsels, I feel it appropriate to refer the matter to mediation center, district mediation center, Raurkela, and the mediation center, the coordinator of mediation center, issue appropriate notice to the stakeholders, and after exploring the possibility of settlement, so file a report before this court, lease the matter on immediately after the 24th. Not 24th, give it
2 weeks after vacation.
1 week after. Okay. 1 week after. Give a date. Report will be filed by that time. Yes.
My lord.
50. It's 50. I would pray for some time. I have not been able to contact my lords.
2009.
Yes, my lord. In fact, I was going through the brief also, which is not, I am not able to gather the brief from my office.
Dismissed on the ground of limitation. The revisional court may reverse the order passed by the magistrate. The complaint case is maintainable in view of the revisional court. Against that order, my Leonard.
Is there any stay?
Yes, my lord. There is a stay.
In view of the Leonard Honorable Supreme Court of my lord, I think my lord, I have no instruction. Case only my lord, here is the case my lord, only limitation. Prior to the amendment, my lord, whether the court has power to pardon the delay of filing of the complaint.
Now the regime has changed. The complaint case is of which year?
The complaint is of the year 2008.
Yes, see, what is the check amount?
3 lakhs.
There is no end to it all. 2008, now we are just see 2026. 138 complaint case. Which area?
Cochin Bank.
Will you settle?
There was an order for settlement also. That was way back in 2011. That is what I am able to see from the records. Well, more specifically, since there is no instruction, I am only bring. Let me.
What I'll do is, but best thing is I'll dismiss it on non-prosecution, ignoring your presence. Let us see what.
No, my lord, that will be
What
prejudicial.
do you tell me?
That's one date your lordship may grant us. I was not able to also find out the
20th,
file.
20th, last of all.
But I'm only praying, let it come after vacation.
No,
The work of
no
these.
question. These are the matters specifically assigned to this court to see that it is disposed of before.
My lords, I am only praying
No
for the
question.
logical.
I'll pass the order.
But since I have no instructions also.
Instruction, that's right.
That is-
But I see these are the matters pending since 2000.
If your lordship
Imagine.
grant me 1 week's time, at least I have sent letters. and
Okay,
I'll-
I'll put it on 21st.
But sir, therefore, I'm praying first week of the vacations.
No,
so that
that's
in the
that's
meantime,
not,
I'll
that's-
try to gather
that's-
some information.
That's not the the idea to lease this matter is only because before vacation, because there is See,
Your lordship
it
will
goes
also
to
have to
Lok
see
Adalat. You
substantial
don't, you
justice
people
is
don't go to
also
Lok
brought to
Adalat.
both the parties.
What kind of efforts the courts are taking? You just see.
I contribute to that.
Lok Adalat, nobody goes. What is this?
Both.
We spend a lot of money for this Lok Adalat, pre-Lok Adalat. You have no respect.
We have tried to send him letters. We're just awaiting if there is any communication at their end.
That is the reason these matters are leaked. Because in Lok Adalat, what is happening is Lok Adalat has no power.
Therefore, I am praying
We
let
are
it come in
organizing the entire machinery is mobilized for Lok Adalat. There is no respect. Nobody comes. And complaint comes, accused.
Once we saw the Lok Adalat list, we have sent
power
letters.
to dispose of all the matters.
Once we have seen the Lok Adalat list, we have sent letter.
21st. Yes, next.
But I'm only praying until and unless I get
I
communication.
treat your case separately than the other.
Therefore, I'm praying some reasonable time. Your lordship may grant me first.
That is the
week of
reasonable
March.
I'm saying. That is the reasonable.
Well, until and unless-
2009 till we are in 2026. What reasonableness you are asking about?
But I have sent the letters,
Maybe.
but therefore I'm praying.
Let us see. 22nd we'll see. 21st we'll see what happens.
Beg your pardon for the indulgence, Your Lordship. Item 31, Your Lordship, passed over. Due to some technical error, Your Lordship, my senior is online. Can you?
I'll see that. Take it.
The matters we have, but we do not have the death certificate or anything on it. So may I pray that
Record your statement, please.
he was 65 years when the revision was filed.
The present criminal revision petition is pending since 2009, challenging the order dated. You are the accused.
My lords. In both the matters, he is the same petitioner. Two separate cases were initiated.
Accused, huh?
Again.
Accused whereby he has been convicted. Challenging the order dated 9/9/2009, passed by the additional sessions judge, fast track court 4 of Bhubaneswar, whereby the petitioner has been, you have challenged this, what I see, first you have been, whereby the judgment of conviction and order of sentence passed by JMFC Bhubaneswar in 1 CC case number 1761 of 2003 has been upheld by the appellate court, upheld by the court of appellate court, that is first edition.
Ad hoc first.
Ad hoc first. You take it.
Ad hoc.
Mr. Pandar.
Fast track 4.
Mr. Pandar, learned counsel for the petitioner submits appellate. Petitioner revision petition submits that the as per his instruction, the petitioner has already expired.
Lordship may just say that he has no instruction because we presume that he has died because he's
You
65.
said that he has died?
Lordship may dispose it of in that way that in case...
Unless I record your statement, how can I dispose? I will ask
in that way, I will submit, I have no instruction. That is better for. If the legal heads, they come up...
That the petitioner appears to have expired, so and he has no instruction.
My lord.
He has no instruction. Since the revision is pending since 2009, not intend to keep the matter alive anymore. Hence, the petition is disposed of.
52 also a separate case, same petitioner. The case numbers will be different.
Dismiss. 54 for non-prosecution. Yes.
Great.
For both 52, 53, yeah? 51, 52. No, 51, 52. 51, 52. Yes.
51, 52, complete a different case.
54. Yes, 54.
I am for the petitioner.
Yes, madam.
So can we see order dated 24/6/2013. 6/2013.
24?
24/6/2013.
There is no.
Check amount is
Check amount is
46,000.
46,000.
And 80,000 malad
Check amount is
compensation.
Check amount 46,000.
6,000. 46,000.
46.
Compensation is 50,000.
80,000.
80,000.
This honorable court.
Have you deposited 50? Realization and compensation amount shall remain state subject to the petitioner depositing 50,000. Have you deposited 50,000?
The opposite party has already been died.
I have no instruction. My learned friend says my client was died.
Died.
You are for petitioner.
I am for complaint.
You are for the accused.
Accused.
50,000 have you deposited?
Yes, deposit or maybe check amount to
Memo number so defense so to the
receive की करिए पैसा receive करिए complaint has already been died.
flag D.
Legal हेयर किसी करिए ना legal हेयर तो
Yes, flag D just see. Flag D can't. For extension of time to deposit. Extension of time granted. Extension of time you sought for in 2014. 15 days time for complying. Have you deposited or not?
I have not deposited. No.
I'll dismiss it. Simply dismiss.
Let's fix a date for I will pay the check amount. Only check amount.
No, madam, you try to appreciate 46,000 rupees is the check.
Check amount.
Court says that you give 80,000. Okay. And while interim order was passed by this court said that you deposit 50,000.
50,000.
Okay. And this order was passed in 2014. And for 50,000, you have been, prosecuting the case for about 20 years. And you expect that again time will be granted.
In the meantime, he is suffering from mentally disorder.
Who?
The petitioner.
So then it's better that I'll
That
dismiss.
is why
Whatever has happened. The consequence will follow. I'll simply dismiss because you have been, convicted. And if the 50,000 rupees deposited, he will realize that. Kind of petitioner by filing the revision petition has said the order judgment dated 23
last chance may be given a
2009 passed by the ad hoc additional sessions judge fast track 4 Bhubaneswar in criminal appeal number 21/2 of 2008, whereby the judgment of conviction and order of sentence passed by the learned JMFC Bhubaneswar in 1 CC case number 5814 of 2004 has been upheld. The courts below have directed the petitioner to pay the compensation.
So I am ready to deposit 50,000.
As against the honor of check of rupees 47,000.
46,000.
46,000. 46,000.
That's
By
it.
order dated 24/6/2013, this court paid the realization of the compensation, the total compensation amount of 80,000, subject to the petitioner depositing rupees 50,000. 50,000 before the trial court. And the petitioner again moved an application for extension of time, which was granted by this court by order dated 29/10/2014. The petitioner, the counsel of Mr. Dey, appearing for the petitioner, has no instruction as to whether the 50,000 has already been deposited or not. And this is going to appear for the respondent. Your client is died.
I have no instruction.
My instruction is that.
Yes, to substitute.
As per his instruction, the respondent was already died. An attempt was made by made to settle the dispute by in the second Lok Adalat held on 18 years. Held on May 2nd. Second May 18 years. So and so, so and so. But unfortunately, none of the parties have appeared before Lok Adalat. Hence the matter is.
No, I am appearing last.
No, in the Lok Adalat nobody.
Lok Adalat, I am appearing this. Lordship, last Lok Adalat.
I have to see the order. That is there in front of me. What can I do? Your appearance is not there.
Order to him to the you ask me the
Petition is pending.
Nine.
Is there any out of it? Complaint is up 2008.
Nothing is man.
Complaint is 2000.
2008. I am not inclined to further. I am not inclined to request.
One CC case 2004.
2004. I'm not inclined to.
May I? Let's may I? Mediation को at least.
No, dismiss. What medicine? He's died in one hand. He says died. You have not. You don't know deposit. For 50,000, don't waste time.
Last.
I have dismissed it.
Lok Adalat, I am appearing the petitioner.
No, I have to go by these orders. You people have to respect the proceedings of this court. 2004, 138 case. And it is pending till 2026. What is happening?
I am ready to.
Whenever the matter comes, you answer.
The matter.
Nothing.
The complaint has already been filed. Who can? कहीं तो रिसीव करिया को नथिले आई एम रेडी टू
ठीक है then the consequence will follow. It is matter of 80,000. You have to pay, that's all. Heaven is not going to fall. 50,000 you have already paid. 30,000 rupees paid. Finished up. Whether he will take or he will not take, whether he died, is none of your business. For 30,000 rupees, you expect that the High Court will keep on entertaining for 20 years a matter. Yes, next.
55. Your Lordship, I am for the respondent, Your Lordship.
How much judicial time is wasted, you know, for these matters?
Last occasion, I appear the
but in the
Lok Adalat
order, just see from here. Your appearance, nothing is there.
Lordship, I appear last occasion.
I have to go by the order or I have to go by your statement?
Order कौन ହେଇଥିବ ମୁଁ ଜାଣିନି ମୁଁ appear କଲି କେହି ତାଙ୍କର ନଥିଲେ ଆପଣଙ୍କ ନିଜ କୋର୍ଟ ଆପଣଙ୍କର ନିଜ କୋର୍ଟ ମୁଁ appear କଲି
No, Justice Satpathy, just see. Don't make
ତା ପୂର୍ବରୁ ତା ପରଟା ଆପଣଙ୍କ କୋର୍ଟରେ ଏଟା ଉଠିଥିଲା.
Just see the order. Justice Satpathy's order. Why are you making that statement?
ମୁଁ ଯାଇଛି appear କରିଛି.
Right on. Next.
55. Your Lordship.
Yes.
May it please the court. I am for the respondent, Your Lordship.
Yes.
I was the complainant in the court.
Who is the appeal?
Petitioner.
Same story.
RK Naik.
What is the check amount?
Check amount is 1,10,000, Your Lordship.
Yes. You are the respondent.
Yes, Your Lordship.
Yes. Petitioner is not there. File was finished.
He is challenging the order of appeal.
Has he deposited 50,000 rupees?
It was a condition of his bail, Your Lordship.
Huh?
It was a condition for his bail, Your Lordship.
Permission for his?
Condition for his bail, Your Lordship.
Has he deposited that money? That's what I'm asking.
I have no instruction on that matter, Your Lordship.
50,000
Yes, Your
to surety. Amount he deposited or surety?
Which surety?
Nothing is there. None appeals for the petitioner, so also appeal for the respondent. In the interest of justice, last opportunity is granted. Please the matter on Tuesday. Tuesday will be dismissed if he doesn't come. Make clear that the petitioner doesn't appear on the next date of hearing. The same shall be the revision shall be disposed of on its own merit. Yes.
56.
Lord, I am in virtual blood.
Yes, sir.
I am for the petitioner, Lord. Lord, it's a 2009 matter, and actually in the file in my office is missing somewhere, but I am trying to contact my client, and I think we'll be going for the compromise in the next local adalat.
What is the check amount?
Some, but actually I don't remember because I don't have the file now with my table.
What is the check amount, sir?
Maybe of 5 to 7 lakhs or something like that. We are missing the file, that's why I'm unable to tell the exact figure.
See, the problem is, see, this matter is pending since
2009 is pending, I know. And there is no
And you have been
contact with
convicted. You have been convicted by two
Yes,
courts.
yes, my lord. Yes, that I agree, my lord. If it can be taken up after vacation, my lord, in the next
No, no question of after vacation. Come on Tuesday. Land Council for the petitioner seeks an adjournment in the interest of justice. Please the matter on Tuesday. It's made clear that no further adjournment and any court shall be granted in this matter. Nothing doing. Go on. Before vacation, everything has to be disposed of. Yes, next.
57.
You come and take the file today. Even
Yes, I am trying to take it, my lord.
Take the soft copy you are allowed to take.
Yes.
Yes.
57, Your Lordship.
Yes, sir.
On behalf of Mr. Behera, I am for the petitioner. Yesterday could not be communicated with the petitioner, Lordship. Want to adjournment.
Why have you not appeared before the Lok Adalat?
Lok Adalat रे तांगर तो communicate ही पाला नहीं.
Say that service is there, everybody appears. You don't respect Lok Adalat.
There is
whole difficulty.
So there is possibility of settlement between the parties.
You settle it. How much? What is the settlement amount?
What
is the check amount?
2.5 lakhs.
So deposit here. Check amount.
Short adjournment.
Settlement means check amount. The complaint was filed when?
Is selling the conviction order.
This is convicted
in 2009.
2009.
Yes,
the complaint was filed on. When is the date of complaint? 2003 complaint.
Yes, sir.
So what is the check amount? 2 lakh something.
Yes, sir.
Deposit that amount. Forget about the interest part and compensation. What is the compensation? What is the compensation? Compensation is just the compensation. 2,50,000 declined issue check control due to the court will dismiss.
3 lakhs.
3 lakhs. 3 lakhs.
Yes. 2 lakhs is deposit.
Short adjournment maybe.
Short means Tuesday.
Yes, sir.
Tuesday. Okay.
Take instruction.
Counsel for the petition submits that there is a chance of settlement in this matter. The revision petition is arising out of a complaint case filed on 2003 for release for the honor of check of rupees 2,50,000. The trial court convicted the petitioner and directed the petitioner to pay compensation for 3 lakh rupees, which has been upheld by the appellate court. Against the appellate court judgment, the present revision petition has been filed. Counsel for the petitioner submits that there is a chance of settlement. Release the matter on Tuesday.
Yes, sir.
Top of the check, then I'll entertain.
Yes, sir.
Otherwise, I'll simply dismiss.
Yes, sir.
Yes.
Always.
58. Yes.
I have come with this to be prepared to pass the 160 case. Because I have not taken any amount from that company. I have taken an amount from Magmali's finance. In the petition.
You have asked for discharge or what? Against the conviction?
No.
Against the conviction, discharge.
नहीं conviction नहीं cognizance है cognizance पर इन्होंने discharge petition पकेले 138 that was
rejected and therefore
now they have come.
But what is happening to the complaint case? By now complaint case might have been disposed of. Where is the stay? Or there is any stay?
58.
The further proceeding is stayed. Why did that is a tribal thing that has to be tried
on the face of the record. You not seen my
show me.
Annex
1. Yes.
Annex 1 page 9. The last signature of a video person, Magma using fine limited. For arbitration.
In terms of arbitration agreement, we hereby appoint you as an arbitrator to adjudicate the said dispute and or so and so. Yes.
Magma leasing limited. I have forwarded the one. And thereafter the notice was issued. And next page, Annex 2, that is the Magma leasing limited. But the complaint filed by the Magma team which is no way connected with
Magma Leasing Limited.
Okay.
This is 138 notice or arbitration notice. Show me the 138 notice. Arbitration is something different.
The prima facie I am showing that I have.
You show me the 138.
Competition is annexure 3.
Magma Finance Corporation Limited.
Magma Film Corporation, which is no way connected. In the paragraph H, they have admitted that.
Paragraph
H. Page 14.
Yes.
The complaint petition.
Yes.
That the notice order 138 NI Act was issued against the above noted accused person in the name of company Magma Subsea Finance Ltd, but subsequently it has been seen as a Magma Film Corporation. These two companies I have no way connected with this. I am Magma Leasing.
Magma
Leasing. See, Magma Subsea Finance or Magma Film Corporation. କିନ୍ତୁ ମୁଁ ଏ ଦିଟା କମ୍ପାନୀ କାହା ସାଙ୍ଗରେ ମୋର ନେକ୍ସସ୍ ନାହିଁ। ମୁଁ ହଉଛି ନେଇଛି ଲୋନଟା ହଉଛି ମାଗଣା ଲିଜିଂ ତା ସାଙ୍ଗରେ ମଧ୍ୟ ଆମର କମ୍ପ୍ରମାଇଜ ହେଇଯାଇଛି।
Where is the 138 notice? That's what I'm saying.
Notice was not a solve.
Where is the check? Do you have the photocopy of the check?
Only advertise.
Photocopy of the check.
Yes,
photocopy of the check.
Check what? 12,000 some.
No photocopy. Do you have the check? Where is the check? Particulars of the check. Let us see.
Check what?
Magma.
They have taken a blank check.
See,
this person
why don't you see the come to page 11. Page 11. You have issued a check to Magma Finance Corporation Limited.
No. I will show you. I have
just see the see the no will not make no. Just see. Page 11.
This is the complaint.
Come to page 11.
This is their complaint. They have taken the one Sitasu Sharma has taken the check and blank checks. That is from.
So that is your defense.
I can move.
Just see. Can you please come to page 11?
Right.
The complaint. Just see. What is it written? Documents relied on. Check number so and so. Date 2/4/2008. 51,133 rupees. Central Bank of India in favor of Magma Finance Corporation Limited. That is what you have issued.
Blank check has been misused.
That is your defense. That is your defense. Blank check. Have you filed an FIR?
The record was called for.
I'll see the record. I'll pass the order. Where is the record? Let us see.
LCR has not come.
See, that is.
Who item that? Not yet received. Why HCR is not received? It was called for 2009. The check was issued to Magma Finance Corporation Limited. Let us see.
Neither have taken a loan from that company. Why that blank check which was given to Magma Leasing Ltd. That person has given this check to that blank check was taken. 80 blank checks.
Can you see page 17 of the brief?
You have taken loan from
Magma Leasing Ltd.
Magma?
Magma
Finance Corporation. Where is that?
That is the notice given for
That is again you are referring to arbitration.
arbitration.
Arbitration is something different.
Company.
Krishna, kindly see page 17.
No, this is
Page 17, paragraph
17.
They say they have taken
Yes, that I read. The
Yes.
complaint has to be tested in trial only.
No, but those they say that they have given
These
the
are all
blank check.
defense.
Yes, Lord.
Some arbitration proceeding is going on with another
And the
company.
NI Act presumption is
And
always
why have you issued the check in first stage?
I have taken a loan from the.
That's it. That is what.
The car was seized.
Why have you
They sold the
answer that? Why have you issued the check in the name of Magna Finance Corporation?
I have
Finance
not.
Corporation.
I have not.
The check has gone like this.
Only blank checks were taken.
That is what is the defense
Blank
is.
checks given by the to the Magma leasing unit.
So according to you, this has been misused by Magna Finance.
Right.
Have you filed any complaint case anywhere? FIR anywhere? It is misused or anything? Show me that. The test is the check is issued.
Check was given to Magma leasing.
Again, you are saying unnecessary wasting time.
So that is well.
I will pass the order. I'll pass the order.
Record record.
No, I'll pass the order. Record is enough. This record is enough for 138. Is only 51,133 rupees.
Already
One installment for which this matter is pending since 2007.
There was compromising in the first company where we have taken the loan.
We'll see.
It is otherwise I will be penalized without
penalized.
taking loan.
Whether this company is still, the company is still in existence or what? Magma Finance. They may not be. They might have lost the interest also. For 51,000, they would spend more money to defend this case. Therefore, nobody is coming.
They have filed, someone has appeared that they filed their vakalat, probably he's not there. Name is reflected in the cost.
Argument for that part. Since nobody appears for opposite party number 2, leaves the matter on 20th. Yes, 20th. That I decided. I heard it. 20th. Next.
59.
20th. Yes. 59, yes.
59.
Interim in 50.
The interim order is only because of the interim order only this problem. 3 decades this matter will never be decided. For 51 and sorry 10,000 rupees for missing bail one of so what happened here? Service non non-APS for the petitioner, and even non-appeal for the parties. Even local second local held on services non-appeal for the parties. In the interest of justice, release the matter on 20th. It's made clear that no further adjournment shall be granted in this matter. So list me some that if nobody comes. Yes.
Item 60.
60 counter have not filed by the opposite party number 4.
Mr. BK Das. Requisite filed for opposite party number 4. I have found remaining 7 matters. All happened. 2 o'clock we have come back and pass on also. I'll take it.
I want to make a mention, my lord.
Yes.
My lord, yesterday's item number 13. My lord have said that the matter will be listed on next week. My lord, that is listed for after vacation. Co-accused are already released on bail, my lords. That's
right, but we have to see our schedule also. It's not necessary that all the matters.
That my lord's convenience, any day next week, my lords.
Tuesday, 100 plus matters.
One item, affidavit already filed that the local.
Seeking, where there is a stay, seeking time for 20 years. Since last 20 years, the matters are pending.
This is a bail matter outside.
Check amount 50,000. Since last 20 years, can you imagine? stay orders are.
My lord is gracious enough. My lord is
Not
also
listed
granting
the matter.
everything, madam.
And if you don't dispose up, it will remain like this for another 30 years.
My lord, I don't know. My lord.
And I'll take it up after lunch.
I'm a pardon, virtual code, my lord. Item 30.
I'll take it up, sir. I'm sitting after 2.
May pray on Monday only. Only one day.
Monday, see, lot of matters what to do.
I'll not take only 2 to 3 minutes. It's a matter where 2 things are.
Tuesday 100 plus already. Wednesday already 60 plus.
More
Next
than
week
my
will
lord.
be very tough.
Friday accommodate कर दो. Friday की गुरुवार after vacation है गले my lord होटल को outside.
No application during vacation.
May pray for Monday.
Great good.
Item number 5. What happened? Huh? Okay. Yes. What is this one here? Item 5. Yes.
This is the yes.
What are the allegations?
1 under 109. We have returned the file. Can I pray for tomorrow? Monday, Your Worship.
What are the allegations, by the way?
Yes. 109 is there.
What injuries?
There is no injury.
Where from I'll get it? Have you filed anything?
Case of a counterfeit.
Maybe, but get it Monday. Let it be on Monday. Monday. Huh? Monday. Yes. Yes.
Password item 15.
Debit code. Hmm?
Annexure 3 is not properly placed.
Annexure 3.
And page noted.
NDPS 60 kg 500 gram is from outside.
Not there. Defective petition filed. Bail application was rejected when?
The lower court.
That is also not filed. What kind of petition is this? When is bail application rejected? Aadhaar card,
Common order plan B. Common order plan B.
Flag B. Anonymity is for the petitioner. Please after vacation. Let it be after vacation. Nobody is there. Why should I do? Yes.
Item 31.
May I I'm on BC,
Yes.
It's a case of 139 Act where I have challenged the order of cognizance. I have challenged the order of cognizance on mainly on 2 grounds, my lord. 141(1), 138(c) of the NI Act has not been complied, my lord, which is mandatory in nature. 141(1) says, in a case of 138, my lord, the company, the trust or the firm
must be a party vis-a-vis the other signatory, my lord. It's a case, it's a trust, where the two signatories are there, the secretary and the director, my lord. Whereas the trust has not been made a party. And so far 138C is concerned, a time-bound period is there, where it gives a ample breathing period for the accused to pay the amount after the notice be issued. And the particular breathing period is 15 days after the issuance of notice. 15 days, clear 15 days notice is there, prime time period is there. So 15 days starts from the 16 days of receipt of the notice, my lord. Here, admittedly, the particular complaint has been filed on 30th of January 2000.
You are appealing for the opposite party.
Yes. Yes.
And by the opposite accused, my lord.
Yes, yes.
So on these two grounds, I have filed the application. And mainly on this ground, and besides another ground I have taken, the check has been, my lord may see, connected to, that is the check, where the check has been issued by the one Suniti. But the complaint case has been filed by against Sunita.
Annexure 3. Safety is issued by director.
Yes, one director. Again. No, my lord may see the secretary, Sunita.
Sunita Patnaik has issued the check.
Suniti Patnaik has issued the check. My lord may see the signature. But they filed the application against Sunita. My lord may see the cost title. That is one aspect. That is not very much important, because two aspects is important. That is clearly and mandatorily is to be fulfilled. That is 141(1), 138C, my lord. So admittedly, as I have taken this, and admittedly I have taken this ground that the complaint has been filed within the period of 15 days. That means the complaint may see to my that ground number, the para 7, where I have said the notice has been issued on 24/1, my lord.
Yes.
And it was returned on 30/1, my lord. And the complaint petition has been filed on 18/2. So within a period of 30 days, it has been filed. So, but it requires the 15 days clear, and thereafter 15 days breathing period for the accused to pay the money, or at least to think about to pay the money.
I got it. Yes.
So far as the first submission is concerned with regard to trust being required, that the Honorable Supreme Court has recently decided that trust is not equated with company, and trust and so the trust is not required to be paid a party.
It was purchased for construction.
For construction.
Toilet.
Of hardware items.
Hardware item purchased from Bhavani Traders.
Yes, they had purchased from me and they did not pay, and there was an agreement. I filed the agreement with the reply affidavit. With the agreement, they had given this check as post-dated check.
Yes.
And the check also which has been filed is not the check for which cognizance has been taken. If your lordship may see Annexure 3, the check number is 221354.
Yes.
And the cognizance order, if your lordship may see page 12.
222135, 226 or 1?
I'm sorry, 22, it looks like 22.
Whatever, 354.
354.
Cognizance
order, page 12, and even the complaint, if your lordship may see, page 12, cognizance order.
114494.
And even the complaint petition, page 7, also the check number is 11494. So the check which has been filed is not the correct check. I have also taken that ground in my reply affidavit, which I had filed.
Yes.
My humble submission is, I have given a check, that means the entirety.
You built up your case on the basis of Annexure 3, which is absolutely not connected with this case.
No, my lord, kindly bear with it. I have, because of the fact that the check has been issued and it was lying with my friend or the clients of my friend, that's why I have not made the particular check. But in the check, each and every check, well, these things is there. My lord, my friend, my lord, kindly.
Where is that check? That is number 114494.
Lying with the court, my lord. Lying with the court. It is lying.
Then why? What is this check then? Annexure 3.
No, Annexure 3 is the check. Why I have said so? That is the each and every checkbook of the present petitioners. Sorry, the petitioners, my lord.
No. This is completely.
Contains this, my lord.
Why have you filed Annexure 3? What is the relevancy of Annexure 3 to this case?
My lord is posing the right question. Is my humble answer that in each and every checkbook of the present petitioners, this my lord stamp is there.
No. That's we have to see the check in subject.
Yes, but check in subject. My lord may give me
Which is the check in subject?
My lord may give me one day. My lord may keep it to Tuesday or Wednesday. I will get the certified copy of this check, my lord. Only one day, not more than that.
But I want to know why you have filed Annexure 3.
Yes, my lord. My lord, I have filed this Annexure 3 on the instruction that each and every checkbook, of the petitioners, my lord, that contains this, my lord. Each and every checkbook, my lord.
You come to para 8 of your petition.
My lord, I am coming.
Read it.
My lord, my lord.
The petitioner respectfully submits that the LA check,
my lord,
has been issued by Struti,
Sushti again.
which is a trust duly registered under the authorized so-and-so.
My lord, may read,
So
read
this statement is completely misleading.
Which statement, my lord? 8.
Para 8 of your petition.
That the petitioner has submitted as the Ali's check has been issued by Sushti, which is a trust duly registered under the authorities, and moreover the Ali's transaction was made between Bhavani Traders with the Sushti, and the bills who was allegedly in favor of the Sushti, and the petitioner as mere director and the said trust is admittedly as the complainant petition has not been filed in the name of the said trust. As per 141(1) I placed before my lord. But although the bank account as such and such was made to have operated only in favor of the trust, under such circumstance, in view of the settled position of law, such and such, it is not sustainable, my lord. That's why I've said so.
What is the relevancy of this check? I don't understand. Okay, Monday you come.
Monday, copy kadi kali chuti, pordon chuti. Monday, Tuesday, give me my time, my lord. I'll produce it, my lord.
Monday, Tuesday. Tuesday you come and satisfy.
Wednesday, my lord. Only one day more. I'll get a copy from
Tuesday. That instead of Monday, I'm giving it Tuesday. Yes.
Saturday, Sunday, there will be holiday. Sunday, Monday, I'll get the copy by Tuesday, my lord. I'll take it away.
Okay, Wednesday. You remind. Otherwise, I'll vacate this day.
Yes, my lord.
Vacate. Yes.
Entry model till Wednesday.
Yes. Okay.
I pray entry model continue till.
Why have you not moved application for vacation of stay? If this is the case.
No, we have filed and
you are also
we had filed a reply and also tried to mention also a few times. But
what did you check amount?
22 lakhs.
Then I don't think you needed the money.
No, it is not.
If this is the case, then you should have pointed out.
Yes, in fact, I pointed out. I filed a reply affidavit also pointing that out.
And the stay is operating since 2022.
22. In fact, it has come also for hearing in 2024 also.
And if you prosecute the case like this, what to do? Yes, next. 32.
I pray entry model continue till Wednesday.
Yes.
Okay.
Yes.
Published.
None appears in the second call. In the interest of justice, please the matter on Tuesday. It's made clear that in the event none appears on that day, the matter will be taken out of the. Yes. 33.
May.
Yes, sir.
Present petitioner, cancelling the very initiation of proceeding on the various ground, my solitary ground before a lordship, that in the instant case, company has not been
What is the status of the complaint case now? 2010 it is filed, and we are in 2026.
26.
It might by now it might have been over.
To that extent, next week any day I will.
Tuesday. See, the petitioner is challenging the very initiation of the proceeding under section 138 NI Act in 1CC case number 372 of
2010.
In the absence of any stay operating in favor of the petitioner, the complaint case which was filed in 2010 might have been tried and closed by now. Mr. Das to seek instruction in that direction and release the matter on Tuesday, Wednesday. Sorry, it's not. You have the 16 years, 130.
But that is on fast out because due to the shortage of petrol, I'm in a queue. Thereafter, I had been.
But I think
That might have been completed.
yes, I'll dismiss it and
Yes. Otherwise, can I pray before Lordship on the last data?
Yes, yes.
If it has not been completed, liberty may can be granted to renew. If it has not been completed, trial has not been completed.
Then I'll dispose it up right now. Right on. कौन लिख लो?
ସେଇଦିନ ଥାଉ ସେଇଦିନ dispose of କଥା.
Dispose of.
Take instruction in that regard.
नहीं आगुर कौन करता?
In absence of stay operating person from the complaint case which is filed into those might have been tried and voted by now.
Since Mr. Das has no instruction regarding the same, this court feels it appropriate to dispose of the matter, giving liberty to the petitioner to renew the prayer, renew the same prayer if the complaint case is not.
If cause action cannot completed or cause action
as yet, dispose of as yet. With this liberty, the petitioner is disposed of.
It will suffice in time.
Yes. Next.
Obligatory.
Item 61.
What is this matter? Against the
Confession
confiscation proceeding.
order.
Anything survives?
Stay
See,
since
95 you have
1995.
taken the stay in. Just imagine what is happening.
My thing also shows that the learned bank is sought for some time to send the records about the
95, this is state what to do.
I don't know, college just after vacation, Mr. Kalku address.
Least learned counsel for the petitioner submits that Mr. Palit, senior counsel is not available, and moreover, the copy of the petition is also not available in the office of learned counsel for the petitioner, since the matter has been pending since 1994, and lastly, the matter was listed on 22/9/2023. The petitioner seeks an adjournment, and as in view of the aforementioned and in the interest of justice, release the matter immediately after it. Immediately after it. Give a date. It's made clear that on the next date appearing, if the petitioner here that the next date appearing and at no circumstances the adjournment shall be given. If the petitioner seek an adjournment, the stay operating.
Any day after 29th of June, my lords. May I pay? Any day after 29th of June.
When the stay order was passed?
My lords, the order
13 to 95. 13 to 95.
The order
My lords,
is
that is-
13 to
That has been
1995.
made absolute, your lordship.
95.
1-3. That has been made
Interim
absolute.
order passed on that is 13 to 1995, which is made absolute on
1-3/1995.
1/3/1995 shall be withdrawn if you seek an adjournment. First week of July.
My lords.
First week of July.
62.
62 also same, your lord.
62 also seek.
My lords, may kindly permit me to take a soft.
It is permitted, you take it right.
My lords, deeply obliged.
63.
63. Admit, issue notice. What is this matter, madam? Admit the issue notice. Nothing is filed except memo.
Asserting the judgment. Asserting the judgment.
Where is that judgment? Nothing is filed. Yes, you are appearing. Huh? What do you want? No, there is nothing filed here. Not even the imbue not judgment. Except the memo of appeal, there is nothing. What are you seeking, by the way? What is this appeal? Therefore, the appeal be allowed. Appeal will be convicted under section 341.
341 was acquitted.
What is the
The police officer is detained.
when he was acquitted? When he was acquitted?
10/4/95.
95. 10-4. The judgment is not there with us. Nothing is there.
Yes.
Huh? TCR is there.
TCR. TCR pays 191.
TCR 191. What is the age of the accused, Jesse?
At the time,
By
30
then
years.
39.
39.
39 in 1994.
What was your age?
35.
38. What is this? What is the status now? Is still surviving or died? What? Huh?
Appeal against acquittal.
Appealment is easy. Same order कर दियो. The counsel for the petitioner as well as the counsel petition shall file the status. Inform this court on the next date of hearing regarding the well-being and status of the appellant as well as the accused. At the same time, the state council is also directed to verify the status and well-being of the appellant as well as the accused from the IIC. Which IIC? Begunia.
At the time of the
FIR could reach reaching.
In fact, the accused, by then he was acting as inspector of vigilance, and his other addresses are not ready.
FIR कहीं register हुई है? सुंदरगढ़.
Arising out of 160.
160.
No, state को. Let you file it. You file it, and it will immediately after December. So, date should date. No.
I have been forwarded.
So, who would have good to Register 30th June. And what we'll do is I was just thinking loud. In so far as the appeal against acquittals are concerned, many lawyers are not coming.
My lord, I have examined that is part. Section 378, core CRPC. That is a appeal against acquittal.
78, yeah?
84. Where any appeal against acquittal filed before the High Court.
378?
4.
Okay. Yes.
The High Court has to grant leave.
In all the cases, leave has been granted.
Once leave granted,
it can't be dismissed.
It cannot.
That is, I know that.
Yes.
That I know.
In cases where the leave not granted.
Granted, I can refuse the leave. That's a different story.
Banishing with landmark judgment.
That we can do it. You can dismiss without granting leave straight away.
Then
but in the 99% cases, in the first day, leave is granted.
Yes.
And one more thing you have to see, in these kind of cases, when the court says admit, whether it is tantamount to granting leave.
No.
No,
For
admit
leave-
means
but-
grant.
No. For leave, court has to examine the.
No, in many cases, what leave granted, admitted. It's all right, one thing.
We
And
don't-
in many cases, what is written, admit. Nothing is there.
Admit.
So admit could be treated as a leave granted.
No.
Obviously, it's leave granted.
First leave will be granted. Then
That is the procedure.
No, then a regular criminal appeal will be filed. That will be admitted.
What have the many cases I have seen, what had happened is the first day only admit.
No.
The procedure before
Admission is the next day after the
Yes.
Before grant of
jump
leave.
how will you treat it?
That,
Can you treat it as a leave already granted? deemed to have been granted.
First a criminal miscase is filed. Then it is converted.
She'll finally admit.
Admit means
Many cases I've seen.
appeal
Even
admits.
the one which you are talking about now,
Now it is
63, just see the proceeding. Here also the same thing might have happened.
minus one and see the order dated 6/6/25.
See, 14/7/1995, simply it is heard, admit, issue notice.
Leave to appeal is not that time.
Leave to appeal has been granted by the order number 2.
Yes.
The application
Here it is granted.
Yes.
But in many cases, no leave is not granted, simply admit.
No, the criminal miscase was filed.
That has to be allowed. And
Then regular criminal appeal is to be filed. Then that is the question.
So what we'll do is, what I am thinking, Mr. Naik, you also think over. In so far as the appellants are concerned, it is against acquittal, all the way matters. State has not filed appeal. So, in true sense, you are the prosecutor in state cases. When complaint case, it is a different story. But instead of engaging any independent lawyer, HMI case query, state counsel will appear for all the appellants, those who are not there. Insofar as the accused persons are concerned, I will appoint amicus curiae. Accused has to be heard because he is an acquitted.
If at all,
If at all, but I have to appoint, I'll dismiss it, that is a different story. But I formally have to appoint someone. So, therefore, in all the cases, you be ready with only you have to see whether perverse finding or not there. Many things. 80 देखी सेट करियो ना acquittal in 1990s and so what will do with that? Okay. 30th, huh? 30th. हाँ सो जाती है. चलो next.
64.
64 a complaint case or what? Let's see. Is it a complaint case? Amicus curiae is appointed already.
Complaint case.
Manaswini Rao engaged in amicus curiae and which is find classification. Manaswini Rao is not there. Manaswini Rao amicus curiae. Council present status of the appellants also, and state council calls for obtaining instruction. And by the order dated 26/3/2025, the state council was directed to obtain instruction through the IAC regarding the well-being and status of the parties to the appeal. Report has not yet been made available. Please submit on 30 to comply with the order. Okay.
Amicus curiae appointment kala mothe se asunati. 80 sanction appointment kari.
Yeah, that's what I'll do. That's it. I'll not meet her. Let I may give one opportunity, 30th and Tuesday. I'll appoint amicus curiae in almost all the cases, all the youngsters, and next day, that is next Tuesday, this full case. Okay. They'll get an opportunity to at least read the file. Yes.
65.
Yes. None of these got the petition. Status report is due. State please the better on 30th. Yes.
66. Stamp reporter कर दो क्लिक एडमिट स्टैम्प रिपोर्टर एडमिट कर दो क्लिक कुछ ऑर्डर लिखा है
ऑर्डर नहीं किसी ने और चलती हो research judicial notice to R3
office note has been activated by the order number 2.
In this case leave is not granted.
नहीं हद से साइकिल लिखा है ऑफिस नोट लिखा
Leave to appeal has been granted by the order number 2.
Where is it?
A office note, right hand side.
Leave granted. Notice issued to respondent, SR, appeal, notice no, notice was issued on leave application. Only notice was issued. Leave not granted.
No, leave to appeal has been granted by the order number 2 dated 10/11/2000.
To decide right side
by Honorable Mr. Justice R.K. Das in criminal miscase number 2682 up to 95.
Where is it?
That criminal miscase is listed by the in the list.
There are page 1. Page 1.
Acha, the top, huh? Okay, the top. Yes, yes. I got it. Oh, R.K. Das and Soms. Okay. Same on. Yes.
67. Second, 57. The appeal against acquittal and for the appellant, the first case. Corporation, civil supply corporation, the 409. Actually, your Lordship, there is also connected appeal. The main person was a storage agent, was the society. He was convicted, and this person was appeal against acquittal of the agent. Both are connected. I am appearing in the first case for the appellant.
I am appearing in the second case.
Second case for?
Second case.
Second case, in that matter.
The second case for appellant.
Appellant. Pardon.
Yes.
Appellant.
Where conviction is there.
The appellant is dead, your lordship.
And second case, appellant is died.
Yes, your lordship.
Appellant died.
The second case appellant died, I am not concerned. I am concerned in the first case.
Can you give the date?
I'll procure that registered letter, your lordship. We have sent a registered letter. It came back as the receiver is deceased.
You give it to,
Yes.
I am passing the order. Which is second, Nilakonta. What again? 364. Also, then counsel for the appellant submits that the sole appellant, Nilakonta body, in the absence of application, so it stands evicted. Yes. Nilakonta is gone. Now,
In the first case.
Bauri Bandhu Ponda.
Right.
Yes.
The agent.
Are you seriously?
Yes, I'll pursue because 409 is there. I know the result, but I'll pursue. Evidence is there. Now he has stated there is no document available to connect that he's also received this stock. But evidence is there. There are documents are there, and this.
And I think Orissa State Civil Service Corporation has a better job to do. Why?
No, better. No, that is true, my person. But
why unnecessary?
No, because there are evidence on record. That's why I'm saying.
What will you do? Can you convict at this stage? You tell me when he was acquitted. When he was acquitted. What is the acquittal order?
Conviction and acquittal one order. That is the ICC case number 15 of 90. That 31st.
90.
95 is the order.
90. But what is the age of this Bauri Bandhu?
He was 46 years in 95.
95. Now what is it?
76.
Will you send him to jail?
Not jail, but
then what will you do? This is an academic only. Academic only. You take instruction. You are serious, then I'll go into it. I'll put it on Tuesday.
Not Tuesday, after vacation.
No, not after vacation. You'll finish it. Small matter. You take instruction. If you are serious, then I'll put it on 30th. Otherwise, why unnecessary? See, 76 years man. Acquitted. And I think you should put an end to it.
Because the Lordship also bring the connected case about the abated because there is a joint one trial. He has
died. Let him die peacefully.
Yeah.
Let him die peacefully. That's the best way of doing it. So please seek instruction. Tuesday we'll see. You tell your clients why unnecessary at this stage. The late say somebody is 80 years near about. Sending him to jail, I don't think. And state has not come.
Yes.
State has not come. Therefore.
No, state has not. No, because the complaint case. State has not.
Anyway, and I think put an end to it. Okay. Thank you.